No, you're totally good.
Good morning, everyone. Welcome to our meeting entitled Proposed Changes to the Federal Regulations for Human Research, session number 4, Enhancing and Clarifying Consent and Establishing Standard Safeguards. How's the audio? Can everybody hear me okay? Awesome. And welcome to everybody who is live streaming. My name is Jill McNair, and I am the Director of Education and Community Outreach for CISCRP. And CISCRP is the Center for Information and Study on Clinical Research Participation. We are a Boston-based nonprofit. We were founded in about 12 years ago. And I was invited here today because we do a lot of patient education. We do live programs across the United States, educating people about what clinical research is, what are the benefits, what are the risks, and how to make an informed decision about whether or not you should participate. And we do not conduct clinical trials, nor do we recruit for them. So the kind folks here who planned the meeting thought I would be a good choice just to moderate the day, kind of just extract information. Let's find out a little bit about this proposed rule and get some conversations started. So let me see if I can make these slides work here. So the goals of today's meeting are to provide helpful background information, provide overview of the proposed changes, review changes specific to informed consent, provide experts' perspectives on changes, encourage Q&A, and encourage official submission of comments. So how many of you here today are members of the public or you're a patient? So we only have one. How about, are the rest of you clinical research professionals? Yes? Excellent. Well, very excited that you're all here. I know there's a lot of people online as well, so we're hoping there's more patients and public online as well. Here's our agenda today. The first session that we're going to talk about is the research landscape. But I do want to mention that today's conversation is really an opportunity to get some dialogue moving. But any questions, any comments that are heard here today are not officially submitted to the docket. So you need to do that yourself. So we encourage you to think about what you want to submit, craft it, and then there's multiple ways. You can do it online or you can do it via mail. And I'm sure that it's on your table, it looks like, and I'm sure they gave you some information in your packet as well. So social media, so you can tweet questions today. How many of you tweet? Me either. I just opened an account like 2 weeks ago. Awesome. So let's see if we can get some tweeters. There are probably many more online today who can tweet. You can also email your question, but you can go old school, and there's comment cards here, and I think we have some stand-up mics as well, so you can use those. So this is the 4th meeting of a series. 1, 2, 3, yep, actually the 5th meeting. I thought there was only 4, but there's the 5th meeting. Oh, this could create debate. But we're in Philadelphia. That's all that counts, and there's been many others. And what's nice about that is they all have been recorded, and you can review them. The partners here today you can see on the screen. And if I keep going forward, I'm sure they'll put up the next slides for our first presenter. So our first presenter is Dr. Emma Marr. She is the co-director for the University of Pennsylvania's Institute for Translational Medicine and Therapeutics. Dr. Marr also serves as the Associate Professor of Medicine and Pharmacology at the University of Pennsylvania, Perelman School of Medicine. She is Executive Chair of the University of Pennsylvania's Institutional Review Board. She is the Associate Vice Provost for Human Subjects Research, Senior Associate Dean for Clinical Research, and Chief Clinical Research Officer. Her educational interests are in the fields of translational research methodology to graduate, pre- and postdoctoral students, and novel modalities for education and pharmacology to undergraduate medical students. Dr. Marr's research interest is the development of novel therapeutics in dyslipidemia. Her clinical practice is focused on cardiovascular risk modification with an emphasis on management of dyslipidemia, hypertension, and women's cardiovascular health. She graduated with her medical doctorate degree from the Royal College of Surgeons in Dublin, Ireland. And please join me in welcoming Dr. Marr to the podium.
Good morning, everybody. And good morning to everybody online as well. It's a pleasure to be here, and I want to thank Vanderbilt for inviting me to participate in this important discussion. As many of you in this room, I'm sure, are aware that since the announcement in early September with respect to the notice for proposed rulemaking, there was a lot of frowning brows, question marks. We struggled through lengthy documents, did our best to distill as best we could, compared notes, listened to OHRP's webcasts, listened to other live streaming, read New England Journal of Medicine editorial and position statements, et cetera, et cetera. And I think we're sort of on the final stretch. Many of us, I believe, are at really formulating a solid, well-informed opinion as to where we stand. Not that we all share the same opinions, of course, but that we get to a point of having informed opinions and being able to share those with the agency so that they might be included in their consideration for what the final version of the common rule will be. My remit is very straightforward. In fact, I would say I have the easiest presentation of the day because it is entirely factual, and it is an attempt to portray what the actual landscape of clinical research is today, not just in the US, but beyond our boundaries. So clinical research is nothing new. It goes way, way back several centuries. I use this in my teaching materials in our doctoral programs at Penn to really try and emphasize that the evolution of clinical research has occurred over a long period of time. And our earliest documented evidence of clinical research actually goes back to the book of Daniel in the Bible, so Galen 2000 BC. But maybe a more modern era, and that's a tongue-in-cheek reference to 1747, is Lynn's treatise, where this particular investigator did what could be called a controlled experiment in 12 individuals who were part of the merchant navy in the UK. And death and disease was rampant amongst the merchant navy when they went out to sea, with many of the sailors failing to return home. Evaluation of the causality of poor health in the navy was a point of interest for Linz. And he did an examination of looking at drinking half a pint of salt water a day for 12 days, starvation, 2 oranges and a lime, a balsam of myrrh, and evaluated the outcome. And lo and behold, the 2 sailors who partook of the 2 oranges and lemon a day, the citrus fruits, were well enough to take care of the rest of the ill. Now, you might guess for a second that there are some ethical quandaries in the method in which he designed his study. But the methodology is, in fact, a good example of human experimentation, and one of the earliest that is in the scientific literature, and this went on to be published. If you move forward, a more traditional type of randomized control trial is evident from 1931. A physician who had an interest in tuberculosis, primarily because he suffered from TB himself, and notably, Anderson was from Waynesboro, Pennsylvania, so he was a native to this state, and we claim him as one of our own. He conducted an experiment in patients who were infected with tuberculosis to examine the impact of a gold-based regimen, which didn't have any proven merit at the time, to see if it had any positive impact on outcome. And he also published his work. He went on to become a notable infectious disease expert in the area of tuberculosis and wrote very important pivotal position statements on this that were published in the peer review literature. From that time on, clinical research has been ever present. We've struggled sometimes with our terminology. We use terms such as patient-oriented research, translational research, clinical trials, observational studies, epidemiological studies, retrospective case control studies, prospective cohort studies. There's no shortage of terminology. It all falls under this one rubric of experimentation that involves the engagement of people, of participants, previously referred to as human subjects. Now, one of the things that has happened over time is that the complexity of the clinical research that we undertake has changed remarkably. The technologies with which that we avail of when conducting clinical research have also markedly improved. But the fundamental underpinnings of the goals and the principles of doing clinical research is to try and improve the human condition. The intention is always there. Pose a question, answer the question with the hope that it will inform how we take care of patients, how we try and prevent disease or treat disease. Now, in the process of doing that, bad things have happened. And there is no shadow of a doubt that our historical context for the way in which clinical research is done anywhere has been driven by responses to scandal. And when you think of that, this slide is in no means comprehensive. There have been so many occurrences of where, in retrospect, you really question, what were we thinking? And this dates back to Nazi experiments done in concentration camps, investigation of syphilis from the Tuskegee experimentation, evaluation of morphological changes in scar formation in prisoners, done here locally. The most recent story of Henrietta Lacks of being able to identify individuals from genome sequencing. These all raise really problematic questions for us. And it is our moral and ethical requirement that we figure out the right way to conduct ourselves and the right way to protect the participants who engage in this activity as our partners. And really figuring out a way, how do we truly engage the entire community of clinical investigators, including our participants, in our discussions as to what is the best way to execute clinical research. So I think it's worthwhile spending a little moment of our time considering our history and what has gone before and what has sort of shaped the common rule as it exists today before the changes that are proposed might take place. So as I'm sure everybody in this room is aware, that as a result of the experimentation that was done in the context of concentration camps in World War II, physicians as well as scientists and Third Reich officers were brought to trial in Nuremberg and were sentenced as a result of the deliberation around the activities that had been conducted. And the array of experiments was vast, from purposeful infection, hypothermia, starvation, psychological torture, all done under the guise of answering questions that were deemed to be appropriate. The outcome of the war tribunal was the Nuremberg Code. Now, there are a couple of things to keep in mind for the discussion today. Was the context for the Nuremberg Code was driven by experimentation that was occurring in prisoners or under extreme conditions. So just remember that as we go forward. But there was a very positive product from this activity. First of all, a requirement that participation as a research participant needs to be voluntary. There needs to be the opportunity that the participant can elect to discontinue their participation at any time, that the purpose of the research is to benefit society, that there has been due consideration of the risks attendant with the participant in the conduct of the research, that every effort should be made to minimize the risk, eliminate suffering and injury. Research should not cause death or disability, and medical research can only be done by qualified scientists. It took until 1964 before there was a recognition that this was a very good place to start. But there were definite opportunities to improve upon this. And there was a lot of commentary at the time, one notable one by Henry Beecher here in the US, about limitations surrounding the elements included in the Nuremberg Code. The code was, I would, in reading the literature now in the 1990s and 2000s, was maybe paid a little bit more attention to in Europe than it was outside of the confines of Europe at the time. But be that as it may, the Declaration of Helsinki, named after the city in which the deliberations occurred, the Nuremberg Code was expanded with a specific reference point. Not only should participation be voluntary, but consent should be obtained in writing. Okay? Interestingly enough, that was not a consideration under Nuremberg. Research must follow a written protocol. So there's actually a prospective plan, and adherence to that plan would be required. Scientific principles should drive the research question and the methodology to be used to answer that question. The potential benefit of the research should outweigh the risks and burdens, particularly in the setting of healthy participants. And here's the key piece: independent peer review. That wasn't included in the Nuremberg Code. So this concept of demonstrating to a body of peers that what you want to do actually makes sense. And it was this that ultimately lay the underpinnings for the Belmont Report, what we typically refer to as the pillars for modern clinical research. And again, I use the term modern clinical research somewhat loosely. Here referred to as the golden rules of research. And there are three basic pillars. The first is this concept of autonomy or respect for persons. The second is the concept of beneficence, and not using either Webster's or, with my heritage, the Oxford English Dictionary, even though I'm Irish, of do no harm, and the third of justice, be fair. And I'm going to spend a little bit of time on these because these remain today as the underpinnings of how we think what the pillars of good research practices should actually be. Now, focus on these was as a result of the convening of a national commission. They utilized these elements in writing the Belmont Report, and in 1991, this was codified into the Common Rule. So I just want you to think for a moment back to 1934, forward to 1979, thinking of 1964, Declaration of Helsinki, the preceding Nuremberg Code. That's a long period of time before you end up with the Common Rule. And the reason why I pause for a moment there is just to think about time intervals. That was 1991. Now we are considering a considerable change to that rule in 2015. 2015. Likely, if it gets through every step, would be codified in 2017, 2018. So what did the Common Rule do that extended beyond the Belmont Report? Well, there had never been definitions put around what research was and what defined a research subject, and we'll describe those here today. It also delved into a specific set of requirements around the peer review process. It formalized the idea of institutional review boards and what the rules were surrounding IRBs. They have modified a little bit over time with interim modifications. It describes how the IRBs would review research and the requirements for granting approval. It provides proscriptive guidance on what needs to be included in informed consent documents and has specific requirements for protection of vulnerable populations, including prisoners, Nazi experiments, acres of skin, the experimentation in Holmesburg Prison here in Philadelphia, children, the Willowbrook experiments, and really recognizes the importance that due special considerations are necessary for vulnerable populations. So if we think about those three principles and we think about, well, how do we currently apply the principles of respect for persons or autonomy, beneficence, and justice, it's actually important, I think, to appreciate, and I think it's reflected in the community that's here in this room, and I would imagine those who are online as well, is that it's very much a shared responsibility. So sometimes we think that everything rests with an IRB, but actually extends way beyond the IRB review. And let me give you a sense of what I mean by that. So when we think about autonomy or respect for persons, and we think that the informed consent process is the primary way in which we uphold this particular responsibility, it requires that the investigator or the sponsor writes an informed consent document that adequately portrays the research study for what it is, inclusive of the fact that it is understandable. Any of you who have written an informed consent document, any of you who have read an informed consent document, any of you who have reviewed an informed consent document, typically need to take a caffeine break after page 2. So this concept of comprehension is actually very, very important and one that is challenging because research has become more complex. Whoops, I'm flicking here like crazy. Okay. So not only should it contain the right information, not only should it be understandable, but it also needs to allow for discontinuation, so voluntariness. And it really comes down to not about the document, but about the process. And I'll refer to that again later on. So the team, the investigator, the research support staff, the sponsor, they put it together, the IRB reviews it. Ultimately, the patient, the participant, the healthy volunteer needs to be able to understand that. The concept of beneficence is that risk is minimized, if at all possible. So the risk-benefit ratio, even in the setting where you can't say there's any benefit to participating, has to be in equipoise. So the investigator has to design the study such that it is doing this. It has to be understandable so the IRB can agree with that determination. Then ultimately the participant has to be on board. And finally, justice. Now this concept of justice is that you don't impose the burden of participating on any particular element of the community, and you don't preclude people from participating. And acres of skin or the Holmesburg experimentation is a very good example of that. The investigation was intended to understand the immunological processes in skin. The investigator had a captive audience in prisoners, but the results didn't necessarily apply to the prisoner community. So justice is a very important principle. So as I said before, human subjects protection is a shared responsibility amongst everybody. It is the IRB, the subjects, the participants, the regulatory authorities, the investigators, the sponsors, and if you're in academic institutions, the academic institution. So what is research? This definition has stood for some time. It's a systematic study designed to develop or contribute to generalizable knowledge. Results are shared with others for interpretation. What is a human subject? And this is important because we will see some maybe dissent on the description of what is a human subject. A living person about whom an investigator obtains personal data and private information. What is informed consent? Informed consent describes a process where a member of the research team explains the research and what is involved. The participant, and here's the important part, has the opportunity to read and understand and ask questions, oftentimes will sign a form, although not always, can leave the study at any time, and very importantly is informed of new risks as the study progresses and information becomes available during the study. So, why make the changes now? Well, as I said before, since it's been implemented in 1991, a lot has changed about how research is being done. Not only has the number of studies grown, but the types of studies, the different sorts of descriptions that I said earlier on, has expanded significantly. And most importantly, technologies have expanded at a pretty phenomenal rate, which is a good thing. But we need to be prepared for them and how they might impact our ability to protect our participants. So as we continue to strive to translate discoveries from the bench, whether it be in an academic environment or in a for-profit sector, the ultimate goal is that we come up with improved abilities to diagnose and treat human disease with the idea that it will benefit the population at large. So overall, the purpose of the proposed changes is to build public trust in the system, especially in light of the sort of persistence of adverse or unintentional consequences. Some of the proposed changes may help to build the public trust, have to do with informed consent. That is the focus of our discussion today. So I want to thank you for taking the time and for your interest in the discussion today. And I know that the panel of speakers will be not only thoughtful, but also provoking in the way in which they address some of these changes. Thank you.
Thank you, Dr. Marr. That was very, very educational. We appreciate it very much. So next, we're going to move on to the overview of the Common Rule. We have Mr. Totten Payne, who is here with us today, who is a policy analyst, Office of Science Policy at the National Institutes of Health. Would you like to come up? Great, welcome. So Mr. Payne is a science policy analyst in the Office of Science Policy, Office of the Director at the National Institutes of Health. He's involved in a variety of science policy issues, including developing policies for human subject protections, particularly for the protection of participant privacy and confidentiality, and informed consent for research, as well as policies for oversight of genomic data sharing, dual-use research, and increasing public access to scientific data. Mr. Payne joined the Office of Science Policy in 2011. He holds a master's degree in history from Columbia University and the London School of Economics. And following his presentation, we're going to be joined by other representatives from the Office of Human Research Protections by phone. So I'll have a vast reservoir of knowledge to be able to get from everybody. So welcome, Mr. Payne. Thank you. Nice to meet you.
Hi. Can everyone hear me? Okay. My name is Totten Payne, and I'm here from the Office of Science Policy at NIH to give you a brief overview of the proposed revisions to the Common Rule in the NPRM. And I'll just start by giving you a bit of background here. So first I'll go over the background on what is the Common Rule is and what an NPRM is. And then I'll give you a brief overview of the major proposals that are in the NPRM for the Common Rule. And then I'll go over a brief explanation of how the public comment process works and how you can submit a comment. Okay, so what is the Common Rule? Well, The Common Rule just refers to the body of federal regulations that establish protections for human subjects in research. And we've already sort of heard some of this, but there are sort of two basic aspects of the Common Rule. The first is that it requires informed consent of participants to participate in research. And the second is that that research is reviewed by an institutional review board that is not associated with the research. And an NPRM simply stands for Notice of Proposed Rulemaking. It's a required part of the process whenever the government wants to change or issue new regulations. Typically, they are published in the Federal Register for a period during which the public can comment before a final rule is issued. And we sort of recognize that the Federal Register is not the most widely read publication, so we're very pleased to be able to be here today to sort of raise awareness of this and to solicit more public comments. So this is really a great opportunity. Okay, and it's called the Common Rule, in fact, because it is common to 18 federal departments and agencies. And you won't find NIH, FDA, or CDC on this list, but that's simply because they're part of the Department of Health and Human Services. And when the rule is issued, the final rule, it'll be joined for the first time by the Department of Labor. So I'll just go over this history very briefly because I think we've heard a bunch of this already. But I'll just draw your attention to 1991 when the Common Rule was adopted by those agencies that you saw. In 2011, there was an advance NPRM, meaning a sort of general description of the changes that are in the NPRM was published then, and a number of public comments were received on it, about 1,000. Those public comments were used to revise the proposal and to issue the one that was published this year on September 8th. And if all goes sort of according to plan, the earliest you might see a final Common Rule would be 2016. So just a brief description of what's in the NPRM itself. First, there's an executive summary that sort of just gives a very general overview of what's in it. Then there's a sort of substantial section that provides all of the kind of rationale for the changes that are in the NPRM. And then it goes through each of the major proposals, including what the current Common Rule says, if it says anything on it, what the ANPRM proposal was on that issue, and what the public comments said in response to the ANPRM proposal, if indeed they said anything. It then describes the NPRM proposals itself, and it asks specific questions on each of these issues. There's 88 in total. Then there's a summary of all of the comments that were received on the ANPRM. And then there's also a regulatory impact assessment, which is just the sort of estimated quantifiable and unquantifiable costs of implementing the proposed regulation. And that's sort of for each of the major changes in the NPRM. And then there's also, finally, the proposed actual regulatory text itself. Okay, so why modernize? I think we've heard some of this already, but as I don't need to tell most of you that research has changed dramatically since 1991. There's been a significant expansion in the number of clinical trials being conducted around the country. There's been a diversification of the types of social science research that is occurring with human participants. More and more research is being conducted in clinical settings and may be, to some extent, blurring the definition between clinical practice and research. There's an increasingly greater number of studies that involve multiple institutions. At NIH, it's nearly half of all studies that we fund are multiple sites. And there's substantially greater scientific data sharing going on. And there's also an increasingly sophisticated ability to extract information from biospecimens that's increasingly being used in research. And lastly, there's a number of new initiatives, such as the President's Precision Medicine Initiative, that are advancing a more participatory model of research, where research participants are viewed more as partners and engaged in the research itself. So there are two overarching goals behind this modernization. The first is to enhance the safeguards and respect for research participants. And the second is to simplify the current oversight system and to reduce inappropriate and unnecessary administrative burdens. And this is achieved through sort of 6 major categories of reforms in the rule. The first is to match the degree of oversight of the research to the level of risk associated with the research. The second is to require consent for research with biospecimens, whether or not those biospecimens are identifiable or non-identified. It also allows the use of broad consent for future unspecified research uses for both biospecimens and identifiable information. There's a number of changes to simplify consent documents and processes. There's a number of changes to increase and sort of establish privacy and security safeguards for biospecimens and for identifiable information. And last, there's a number of changes to streamline IRB review of research and operations. And we're going to be focusing today during the rest of our sessions on simplifying consent documents and processes and the privacy and security safeguards that are being established by the rule. Okay, so the first category of reforms is matching oversight to the level of risk. And this is achieved through both an expansion of the rule on one hand into previously unregulated areas of research, and also through a number of exclusions that would exclude categories of research entirely from all requirements in the NPRM, or in the Common Rule rather, and a number of exemptions which have only some requirements for certain types of research, and a number of requirements are sort of based on the level of risk associated with those categories of research. So this graphic is just intended to give you sort of a general idea of the trend of changing the scope of the Common Rule here. So it's just meant to illustrate that some research is going to be subject to the Common Rule that was not previously, while others that were subject to the Common Rule will have kind of varied degrees of oversight applied to them. And that the idea is, in general, to allow the oversight system to focus resources on research that bears the highest risk for research participants. Okay, so the first change in this category is the expansion of scope of the Common Rule. And the proposal is to cover all clinical trials that are not currently subject to federal regulation, and this includes FDA regulation, that are conducted at an institution that receives federal funding for non-exempt human subjects research that is located in the US. Okay, there are also a number of excluded categories of research that are excluded on the basis of not meeting the definition of research in the rule for the purposes of this regulation. The first category is oral history, journalism, biography, historical scholarship that focuses on specific individuals, collection of data and biospecimens for intelligence or national security or homeland security purposes, collection of data and biospecimens for criminal justice activities by a criminal justice authority, public health surveillance activities on behalf of a public health surveillance, well, a public health authority, and collection of data and biospecimens for an institution's own internal monitoring and program improvement processes. And lastly, there's an exclusion for quality assurance and quality improvement for the delivery of an accepted practice or service. And what this means is that a study that proposed to evaluate an educational process to implement or to improve acceptance or implementation of a accepted medical practice could potentially be excluded from the rule. But a study that evaluated the effectiveness of 2 different accepted medical practices themselves would not necessarily qualify for this exclusion. Okay, and there's also a number of other excluded categories of research that are excluded on the basis of being low risk. The first of these is just research involving information that was originally collected for other purposes, that is, either for research or for clinical purposes, but not for the research that is being conducted here. If the information is publicly available, or it is non-identified and the investigator does not plan to contact or re-identify the individuals. There's also the excluded category of research that would involve gathering non-identified or non-sensitive information through educational tests, surveys or interviews, or observations of public behavior. And I just want to be clear here that when I say non-sensitive, this is not the word that appears in the regulation. This is just to get it to fit on the slide. This actually refers to information that, if it was disclosed, would be unlikely to pose a risk of criminal or civil liability to the participants or to damage their financial standing, their employability, their educational opportunities, or their reputation. Okay, so there are also a number of excluded categories of research that are, because they are both low risk and they are already subject to adequate protections. So most of these are, in this first category here, are activities that are conducted by the federal government, because when the federal government undertakes certain activities, there are certain laws that it has to comply with, particularly for the collection and storage of identifiable information that relates to individuals. So in those cases, a form of consent is already being sought, or at least notification. So basically, anytime research would gather identifiable sensitive information through educational tests, surveys or interviews, or observation of public behavior, if the collection of the information is subject to the Paperwork Reduction Act, which is something that only applies to the government, and the storage and maintenance of that information is subject to the E-Government Act or the Privacy Act, which again is something that only applies to the government, that would be excluded from the common rule. Also, if the government uses information generated or collected by the government itself for non-research purposes, including criminal history data, this would be excluded provided that it was subject to those same laws. And lastly, research, and this does not have to be conducted by the government, but research that involves the collection and analysis of identifiable health information, if regulated by HIPAA, as healthcare operations, research, or public health activities would also be excluded from the rule. And there's one last category of excluded research, which is low-risk biospecimen research. So this would involve research that uses non-identified biospecimens that will not reveal new information about an individual, such as test and assay development and validation, quality assurance and control activities, and proficiency testing of the type that's usually done for laboratories. Okay, so the next category of sort of, it establishes exempt categories of research, and these are exempt, but they all have certain requirements that they must follow in the rule. The most common standard one is that a standard tool has to be used to determine the exemption status of the proposed research, and that it has to be used by an expert or somebody who has knowledge of the regulation. And that when this tool is used, the record that of the outcome of the decision has to be kept and maintained. Certain types of research may also require safeguards to protect the information and biospecimens. Other types of research might require limited IRB review of the consent process. And some types of research might also require that broad consent was obtained using an approved template that will be developed and published by the Secretary of HHS. So the first category of exempt research, or the first categories I should say, are ones that are considered to be very low risk, and these all only require that the exemption determination tool be used and that the decision of that tool be recorded. So this would include research in educational settings or practices that would be unlikely to adversely impact students' opportunities to learn. Research and demonstration projects that are supported by the federal government to evaluate public benefit or service programs, or are actually conducted by the government itself. Research involving benign interventions or video recording if the information is non-identified or not sensitive. And again, when I say not sensitive here, I'm referring back to that earlier definition that if the information was released, it would not cause harm to come to the participants. And last, taste and food quality evaluation studies would also be exempt. So there's another category of exempt research, and it sort of has two parts to it. So the first is for non-interventional research gathering identifiable sensitive information through educational tests, surveys or interviews, or observation of public behavior. And when I say sensitive here, that is the actual word used in the regulation. And second, that secondary research using identifiable sensitive information collected originally for non-research purposes could also be exempt, provided that prior notice was given to the individuals that the information might be used in research, and that the secondary investigator who obtains the information uses it only for that purpose for which they obtained it. And in both of these cases, the only requirements for this type of research would be that the exemption determination would have to be made and recorded, and that safeguards would have to be put in place to protect the information. So the last category of exempt research involves research with biospecimens and identifiable information. So this would include, there's again sort of two parts to this. And the first part of this is that the actual collection of biospecimens and identifiable information, and that's both non-identifiable and identifiable biospecimens, for the establishment of databases and biobanks would be exempt, provided that the exemption determination was made and recorded, safeguards were in place to protect both the information and biospecimens, broad consent was obtained using a template that will be developed by the secretary, and limited IRB review was conducted of the context in which the broad consent was obtained to ensure that it was appropriate. And the sort of second part of this is that secondary research using biospecimens and data that were obtained under that process would be exempt, with only the requirement to make the exemption determination and to record the outcome, and to have in place certain safeguards to protect the information and biospecimens. Okay, so it's worth just noting very briefly how the exclusions and exemptions apply to vulnerable populations. And I should point out that the vulnerable populations are a different part of the regulations than the one that the NPRM is proposing to change. And the NPRM does not actually propose any changes to the subparts that apply to vulnerable populations. So the first is that all of the excluded categories of research apply to vulnerable populations, except non-interventional research with children involving educational tests, surveys, interviews, or observations of public behavior. The exemptions would apply to research involving pregnant women and neonates. That's all of the exempt categories of research. And certain research involving children cannot be exempt. And that would be research involving benign interventions or video recording that is non-identified or not sensitive, and non-interventional research gathering identifiable sensitive information. And lastly, research involving prisoners can never be exempt under any of these categories of research unless the research incidentally involves some prisoners. And what's that? That's intended to get at the fact that your population that's under study might incidentally include some prisoners, but they were not the intended population under study. Okay, so the next major category of reforms is the requirement to obtain consent for the research use of biospecimens. So this would be achieved by changing the definition of human subject to require consent when an investigator obtains, uses, studies, or analyzes biospecimens for research. This would apply regardless of whether the biospecimens are identified or non-identified, with some exceptions that I just pointed out in the excluded and exempt categories. And it would not apply to the collection and use of biospecimens for non-research purposes unless they were to be used for research. So, for example, if a biospecimen is collected for clinical purposes and tested for clinical purposes, that would not require consent for research unless it was used for research. Okay, so in recognition of the fact that this is a significant change in the last several decades of research regulation, there are two alternative proposals included in the NPRM. The first alternative, alternative A, requires consent for research involving the generation or use of whole genome sequence data, whether it's non-identified or not. And this would replace the requirement to obtain consent for the research use of all biospecimens. And alternative B, which would instead require consent for the research, for research involving the generation or use of data that is unique to an individual and could be used in combination with other publicly available data to potentially identify them, whether or not that data is identifiable. There are also a number of changes to IRB waivers of consent to see that these requirements are actually put in place. The first is that there are several additional criteria that have been added to waiving consent for research involving biospecimens. You have to demonstrate that there are compelling scientific reasons for the use of these biospecimens, and that the research could not be conducted with other biospecimens for which consent has actually been obtained. And waiving consent would not be allowed for research with biospecimens or identifiable information if an individual was asked to consent and they declined to participate. And the purpose of these changes is that waiving consent is expected to be rare. So there's also a number of changes to allow broad consent. Broad consent is defined as being applicable for the collection and use of biospecimens and identifiable information for future unspecified research. It must be used with the approved template that would be developed by the Secretary with public comment. And it may be used in conjunction with a specific consent for research or obtained by itself in a clinical setting. There are a number of elements that are described in the broad consent. I won't go through all of them because I think we're going to go over a lot of those later today. And these aren't all the ones that are listed there, but I'll just point out that probably the most significant difference is that there would be a general rather than specific description of the types of research that might be conducted with biospecimens and identifiable information. There's a number of changes to simplify the consent documents. First, the informed consent documents must first include the required elements of consent, and that all other information would only be able to be provided as appendices. But that if it was combined with a HIPAA authorization form, that would have to be provided in the consent form and not in the appendices. And there's a sort of a standard being established in the rule as well that participants must receive the information a reasonable person would need in order to make an informed decision about whether to participate in the research, and that they be given an opportunity to discuss that information. There's a number of changes, as again I think we'll hear later today, for increasing privacy and security safeguards. Research would be required to follow either specific measures that have yet to be but will be published by the Secretary, or measures that are currently required by the HIPAA privacy and security rules. And there's also a number of changes in there for sort of establishing when sharing of biospecimens and identifiable information would be permitted. And in general, IRB review of the sufficiency of these safeguards would not be required. There's also a number of changes for streamlining IRB review, the most substantial of which I think is the requirement for institutions located in the U.S. Engaged in cooperative multi-site research to rely on a single IRB unless IRB review is required by law, or the funding department or agency determines that a single IRB wouldn't be appropriate in that particular case. And there's also a clause that IRBs, rather than research institutions, will be held responsible if IRBs fail to follow the regulations. There's a number of review efficiencies that are intended to allow IRBs to sort of free up resources to focus on more sort of substantial reviews. IRBs will no longer be required to review grant applications. The requirement for continuing review would be eliminated for research that was eligible for expedited review, or for studies that have progressed to the point where only data analysis or accessing follow-up data from standard clinical care is occurring. And if IRBs do choose to conduct continuing review when it's not required, they would have to document their rationale. There's a number of other smaller efficiencies included as well, such that the list of activities that are eligible for expedited review would now be considered to be minimal risk unless a review finds otherwise. So this is currently the reverse. Currently, you have to demonstrate that something that is on the list of activities that's eligible for expedited review is no more than minimal risk, but now the assumption would be that if it's on that list, it is minimal risk. For other minimal risk determinations, there will be a list of minimal risk research activities or guidance that will be published. And there will not be a requirement to report changes in IRB membership to department or agency heads anymore. And there's a number of transition provisions included in the rule. The first is that the effective date of the rule, which means that the date at which the rule takes effect, is 1 year after the publication of the final rule. For research that is begun prior to the effective date, it would not be subject to the new requirements. And biospecimens that are collected before the effective date would be grandfathered, meaning that they would not be subject to the new requirements for consent, provided that they are non-identified. And last, there's a compliance date of 3 years after publication, allowed for two of the most substantial requirements in the rule, which is the new consent requirement for biospecimens and the mandate for single IRB in cooperative research. So just very briefly, the next steps are that the public comment period is expected to close on December 7th of this year. Once the public comments are received, they'll be reviewed and used to develop the final rule, and both the public comments and the final rule will be published. So there are a number of stakeholder meetings, of which this is the last one. The one in Washington, D.C., just because there was a question about why there are 4 rather than 5. The one on October 20th in Washington, D.C. was actually hosted by the Office of Human Research Protections. And we're on the final one on November 18th. But all of these will be archived and available for use later. When you're commenting, you can express general perspectives about the proposed changes. You can express your views about whether modernization is needed or the quality of the overall approach and whether it will actually achieve that. You can comment on specific proposals, or you can respond to any of the 88 specific questions or none of them. There are a number of ways you can comment. You can go to the regulations.gov website and look for the specific NPRM there, or you can go to the Federal Register website and again submit a comment through there, or by fax or mail. And I just want to point out for anybody who's considering submitting a comment that anything that you submit to the docket will be made public, so please don't submit any private information that you would want to be private. Okay, so thank you very much, and please comment.
Does anybody have any questions for Mr. Payne before he goes? We also have a OHRP on the line to answer any questions. I don't see any coming in through live streaming. And will OHRP be with us for the whole afternoon or just segments? Okay. So here's our chance. If anybody has any questions for OHRP, let's get them out now. Okay. Well, thank you, Mr. Payne, for coming out.
Thanks.
Excellent. So we are doing a very good job with our timing. So our next presentation is Informed Consent, What's New and What's Required. Dr. Carson Reeder is the Administrative Director of the Neuroscience Research Institute at The Ohio State University. He has been involved in the development, coordination, and administration of various publicly or privately sponsored single or multi-center clinical or epidemiological research projects. Since 2002, he has served as the research subject advocate for the Clinical Research Center at The Ohio State University. Over that time, he has also served on various data and safety monitoring boards. He also serves as an in-house clinical research consultant for the Center for Clinical and Translational Science and NIH CTSA site, providing regulatory and research ethics protocol development, institutional review board submission, and safety monitoring support. and he has been actively engaged in various related CTSA consortium activities. He earned a Bachelor of Arts in Zoology, Chemistry, and Religion from Ohio University, and his Master's of Science and PhD in Epidemiology from the Ohio State University. Dr. Reeder, welcome, and there you are over there.
Thank you. This presentation is organized into 3 general areas: overview, the current required elements of informed consent, and the NPRM proposed changes regarding informed consent. Informed consent has perhaps received and continues to receive the most attention when it comes to discussions about clinical research, particularly the ethical requirements of clinical research. Yet, it is only one component of these requirements. In fact, consent is truly a construct and outcome of diligence paid to the value, validity, study population, risks, and benefits of a study, and then lived out in the respect for enrolled subjects for each clinical research endeavor. These next few concepts were touched upon by Dr. Maher and Taunton, and this is not to belabor them, but to reinforce their importance. While the concept of consent had and had not been implemented before the mid-20th century, it became an imperative of the Nuremberg Code in 1947. It was the first requirement among 10 presented in response to the Nazi atrocities of human experimentation. The Code states the voluntary consent of the human subject is absolutely essential. However, the Nuremberg Code did not provide for any imperative or enforcement mechanism. As such, its application was not universally accepted, and for some felt only to be applicable to egregious versus paternalistically perceived human experimentation. The next relevant document was the Declaration of Helsinki, first drafted in 1964, with several subsequent revisions since, the most recent being in 2000. It included the requirement that study participants must be adequately informed of the study procedures, its risks and benefits, as well as it included the condition that refusal to participate in a research study must never compromise the medical care to which that individual was otherwise entitled. In 1979, the Belmont Report, as requested by the National Commission, delineated 3 ethical principles central to shaping the ethical framework of human subject research: justice, beneficence, and respect for persons. The report describes respect for persons as treating individuals as autonomous agents. Autonomy includes a person's right to know, including how one will be treated, as well as how information about oneself is used and accessed. Inherent in autonomy is the concept of transparency, which in this context includes any information necessary to make a judgment to participate in research. Obtaining informed consent from individuals is a means of implementation of respect for persons in the research context. The Common Rule, also known as 45 Code of Federal Regulations Part 46, or 45 CFR 46, was first published in 1991, and a Clinical Trial Volunteers Bill of Rights was in fact published in 2002. While today we are focusing more on the document itself, it is important to note that informed consent is indeed a process and not just a signed document. The process is to ensure that each individual as a candidate, subject, and enrolled subject understands the risks and potential benefits of the study so that he or she has sufficient information to make a learned decision as to whether or not to participate and continue to participate in a research study. The document itself has evolved from a simplistic presentation of what will happen during the study, its possible risks and benefits, to a document that is complicated with legal language, often deemed lugubrious, and masking the specific content about a study, and immediately relevant to an individual's decision to participate or not to participate. Currently, as set forth in the Common Rule, these are the basic required elements of informed consent that generally are to be provided. 1. A statement that the study involves research, an explanation of the purposes of the research and the expected duration of the subject's participation, a description of the procedures to be followed, and identification of any procedures which are experimental. A description of any reasonably foreseeable risks or discomforts to the subject. Note that these risks include not only physical injury, but also possible psychological, social, as well as economic harm, discomfort, and/or inconvenience. A description of any benefits to the subject or to others which may reasonably be expected from the research. 4. A disclosure of appropriate alternative procedures or courses of treatment, if any, that might be advantageous to the subject. A statement describing the extent, if any, to which confidentiality of records identifying the subject will be maintained. For research involving more than minimal risk, an explanation as to whether any compensation and an explanation as to whether any medical treatments are available if injury occurs, and if so, what they consist of or where further information may be obtained. An explanation of whom to contact for answers to pertinent questions about the research and research subjects' rights, and whom to contact in the event of research-related injury to the subject, and finally, a statement that participation is indeed voluntary. Refusal to participate will involve no penalty or loss of benefits to which the individual is otherwise entitled, and that the individual may discontinue participation at any time without penalty or loss of benefits to which that subject is otherwise entitled. When appropriate, one or more of the following elements of information shall also be provided to each participant. A certificate of confidentiality, which allows researchers to refuse to disclose names or other identifying characteristics of research subjects in response to legal demands. Such certificates are issued by NIH and other Department of Health and Human Services agencies to researchers to further help protect the privacy of human subjects and their data. Also, a statement that the particular treatment or procedure may involve risks to the subject or to the embryo or a fetus if the subject is or may become pregnant, which are currently unforeseeable. Anticipated circumstances under which the subject's participation may be terminated by the investigator without regard to the subject's consent. And finally, any additional cost to the subject which may result from participation in the research. Additional elements, The consequences of the subject's decision to withdraw from the research and procedures for orderly termination of participation by the subject. A statement that significant new findings developed during the course of the research, which may relate to the subject's willingness to continue participation, will be provided to the subject and the approximate number of participants involved in the study. These elements are not to change under the NPRM. While these elements are requirements of consent, the documents themselves serve merely as the platform and reference for the topics that must be communicated by appropriate members of the research. The proposed new element would require that prospective subjects be informed that their biospecimens may be used for commercial profit and whether the subject will or will not share in that profit. The other proposed new element would require that prospective subjects be informed of whether clinically relevant research results, including individual research results, will be disclosed to subjects, and if so, under what conditions. The final proposed new element would provide subjects or their legally authorized representatives with an option to consent or refuse to consent to investigators or their research personnel recontacting the subject to seek additional information or biospecimens, or the information that would be required to be disclosed under these to discuss participation in another research study. Proposed additional elements of consent is often relevant to an individual's decision of whether to participate in a research study. Currently, such information is sometimes included in informed consent forms under the current common rule. These changes are related to the way information should be presented in the informed consent document. That is, to provide essential information that a reasonable person would want to know at the outset of the document, and to present information in sufficient detail. These will be discussed in the first afternoon session later today. The Health Insurance Portability and Accountability Act, or HIPAA, also called the Privacy Rule, is a federal law that prohibits healthcare providers, that is, physicians, hospitals, clinics, from using or disclosing, quote, protected health information, unquote, or PHI, without written consent from the patients. The NPRM proposes to clarify in the introductory language of the consent that if a HIPAA authorization is combined with consent language, the authorization elements required by 45 CFR 164.508 must be included in the consent document and not in the appendices. In other words, when consent is combined with authorization, the authorization elements should be considered to constitute one of the required elements of consent. Also, when identifiable private information is collected for research purposes, then the document would be required to notify participants if their non-identified information would be utilized for future research studies without additional consent. Specifically, the NPRM proposes to add a new basic element of consent that would apply to any research collection of identifiable private information. One of the following statements about such research collection must be provided to subjects. A statement that identifiers might be removed from the data, and the data that is not identifiable could be used for future research studies or distributed to another investigator for future research studies without additional consent from the subject or the representative, if this might be a possibility. Or a statement that the subject's data collected as part of the research from which identifiers are removed will not be used or distributed for future research studies. The NPRM proposes to require inclusion of these additional elements when appropriate to better ensure that prospective subjects are more consistently provided with this information when it is information that a reasonable person would want to know in order to make an informed decision about whether to participate in a research study or not. These three proposed additional elements of consent are also relevant to seeking an individual's broad consent to the storage, maintenance, and secondary research use of biospecimens or identifiable health private information. So, it is proposed that broad consent also include these additional elements when applicable. Broad consent has been covered in some detail by Taunton and others later. You will receive a link to the presentations and recording with your evaluation following this meeting for additional details on that. Finally, the NPRM proposes a new provision that would require that a copy of the final version of a consent document, absent any signatures, for each clinical trial conducted or supported by a common rule department or agency be posted on a publicly available federal website. The consent form must be published on that website within 60 days after the trial is closed for recruitment. The primary purpose of this provision is to improve the quality of consent forms in federally funded research by assuring that, contrary to current practices, under which it is often very difficult to ever obtain a copy of these documents, they eventually would become subject to public scrutiny. It is anticipated as well that the website will be searchable. This public posting of consent forms is intended to increase transparency, enhance confidence in the research enterprise, increase accountability, and be informative for drafting of future consent documents. A website for these postings is to be developed, or would be developed, by the Department of Health and Human Services, which could then be used by other federal departments or agencies. Or those departments or agencies could create their own websites for the posting of these forms. There are a couple of revisions concerning studies that would be excluded from 45 CFR 46, or the Common Rule, and the addition of categories of exempt research. Taunton touched upon these earlier. Additionally, the NPRM revisions change the conditions and requirements for waiver and alteration of consent. The level of public engagement in the research enterprise is evolving. As such, there is a shift from a paternalistic research environment to one where participants are active players in biomedical and behavioral research. This has been a critical development in this environment. In fact, it has been posited that community engagement is indeed an ethical requirement of human subject research. And as this construct has evolved, so has technology, and consequently the nature of the risks and benefits of conducting and participating in human subjects research. The goal of the recent NPRN concerning changes to the Common Rule, and particularly to consent, is to increase the ability of study participants to make informed decisions by increasing the uniformity of human subjects' protections concerning information disclosure. The rules and proposed rules are to make sure that the process of consent becomes more meaningful by increasing the efficiency in which salient information is presented to candidate subjects and those enrolled in the study, in the documents themselves. Information that a reasonable person would want to know, and that would be presented in a way that highlights the key information. Many have claimed that the consent forms have evolved to protect institutions, rather than protect the human research subjects. If a reasonable balance can be struck between protecting human research subjects and minimizing the administrative burden of the system and all players serving as stewards of the document and process of consent, then trust can be gained and benefit should be maximized. Thank you.
We have a question in the back. Do you want to come to a microphone? We can't, the streaming live won't hear you if you don't go to the microphone. Thank you. Everyone's so shy, and everybody thinks they can yell.
Just to clarify, the posting of the consents, you had said 6 months or a year following the study?
60 days,
60 days.
yes,
Okay, thank you.
upon the close of
Of this-
recruitment.
Close of recruitment. So not closure with IRB in terms of data analysis?
It
Just
does not
close-
speak to that. I
Okay.
just, 60 days from close of recruitment.
Okay, thank you.
Yes.
I'm Mark Schreiner from Children's Hospital of Philadelphia. I have been on an IRB, off and on, but mostly on, since 1980. And starting in the mid-'80s, we identified simplification of the consent form as a major problem, and every single effort to simplify has failed. There's nothing in the NPRN that addresses one of the major issues facing IRBs, and that is that sponsors and steering groups that control clinical studies see themselves as the final arbiter of the content of the consent form. And unless the NPRN includes information such as in the FDA's guidance that the provision of a model consent form is a service, but it is up to the IRB to decide on the final content, then I don't believe anything will change. So we are left often knowing what to do to improve consent forms and what should be in there, and powerless to actually make those changes because we have to decide whether we're going to participate in the study or not, rather than, and I think that there is nothing in this NPRN that at all addresses this, either in the background information or the guidance, and I think that needs to be addressed.
Thank you for your comment.
Any other comments? Questions?
Does it address at all the definition of a reasonable person? Will that be left to the IRB in terms of, is that education level, reading level? I think going to what Mark said.
This reasonable person did not locate that.
So, because I feel like that language is already in there, right? What a reasonable person would understand.
It is an interesting addition, I would agree.
Yeah, okay. Just following up on Mark's comment, completely agree the difference between federally funded and sponsored research. Our consent forms from a sponsor right now are 26 pages, and our federally funded are 7. A significant difference. Now, yes, clinical trials will be much more comprehensive, may include with an RCT in terms of randomization, et cetera. But I still feel like we won't get there without that understanding from the sponsors. Sort of who has the final say.
I fully understand. One thing that I do appreciate in this, though, is some reorganization and presentation, which may improve and highlight, again, that salient information. But it does not directly address your two comments.
Any other comments? We have another one? Can you speak into the microphone?
Sorry, I'm from Hospital for Special Surgery, and I'd say about a little less than a year ago, we changed the format of our consent form. And to your point, what we did is our institution was having a lot of problems having patients who become participants in research study really understand the differences between the procedures that they are going to undergo, which were considered routine, versus those were being undertaken only because they were in that research study. And what we've done is we've reorganized the information in the consent form, and we've also taken out more of the words and put in a chart a graph with X's and SOCs to explain exactly what would be expected of them and which of these procedures would be considered routine. And I think that we've seen a much larger understanding from the patient population that has decided to participate in research as far as what they understand their expected cost would be for their routine care versus research. So,
I think that's
to your
a wonderful.
point, it's worked really well.
I think that's a wonderful construct. That's something that we've done not as across as an institution, but in consultation with other groups. A very efficient way to present that and easily understood pictorially. Thank you.
So, Dr. Reeder, we have potentially patients in the public watching us via live streaming. Is it possible for you to really help us understand the difference between federally funded research and sponsor-funded research and how the rules are different, that it could be a 7-page document versus a 26-page document?
I think your man is right there.
So will you cover that in the next session? Okay, great.
Not to put you on the spot, I think that's quite a
Excellent.
strong charge.
Any other final comments before we move on? Great, thank you so much, sir.
Thank you.
So Dr. Schreiner is our next presenter. He's going to be talking about when is consent needed and can it be obtained without a signed document. Dr. Schreiner is an associate professor of anesthesiology and critical care at the Children's Hospital of Philadelphia, as well as the executive vice chair for the IRB. Dr. Schreiner is interested in the design, execution, and management of pediatric pharmaceutical trials and in the ethical conduct of children as human research subjects. He earned his Bachelor of Arts in Chemistry from the University of Rochester and his medical degree from St. Louis University. Welcome, Dr. Schreiner.
Thank you, and thank you for inviting me. To start with, I just want to say I'm going to do my best. This is all very complicated. I'm not living with this every day like the people at the NIH, so I hope that I can keep it all straight as I present it. First, I'd like to address the question about sponsored research versus federally funded. And there's another category, and that's unsponsored research, which at our institution makes up the majority. Maybe 75% of the research is not sponsored by anybody. And when we say sponsored, we don't mean sponsored by the American Heart Association. We mean sponsored by a pharmaceutical company. If it's research that's regulated by the FDA, then the FDA has different rules for the conduct of human subjects research that are largely similar but also different from the FDA than the OHRP, the common document, the common rule. The FDA's regulations in 21 CFR 312, I think 60, identifies the responsibilities of investigators. It's a sponsor's responsibility to identify an investigator who will follow the regulations, and it is the investigator's responsibility to obtain valid informed consent. The FDA's guidance makes clear that the sponsor may provide a model consent form, but it is this investigator in the IRB that's responsible for the content. So they are giving IRBs permission to have the final say. The reality is sponsors don't treat it that way, and you're left with either accepting unacceptable wording or not participating. The common rule in no way addresses whose responsibility it is, that it is not the steering committee, a 25-year-old research assistant at the main site writing a consent form that holds sway over what the content is in the format. And I find myself struggling all the time with people who don't actually know the regulations or the wording or don't know what, we've seen grade 22 consent forms. And the FDA is specific about what is understandable. They say it's grades 6 to 8. Since the average reading level of participants is slightly less than grade 8, and in the city of Philadelphia, 60% of people read at a basic level or below, which would be grade 6. So what a reasonable person wants to know and what a reasonable person can actually read is very different. Now, what I'm talking about today after all that editorial comment, is when do we not need consent, and when do we not need consent documented in writing? So what I'm not going to talk about is HIPAA and how it integrates with this, because they have different requirements. So the goals of the NPRN are to uphold an individual's autonomy interests and determining their biospecimens, identifiable private information, and how it can be used for secondary research, and to facilitate recruitment of prospective subjects, and to create some more flexible rules for documenting informed consent. So right now, I'll talk about the waiver of documentation of consent first, which people often refer to as verbal consent, but it might not be verbal at all. It might be on a computer screen. It might be in many other settings, but for simplicity, verbal consent. It's permitted, and what people often don't understand, our investigators, is that the requirements for obtaining consent remain the same. The information that must be transmitted is the same. It's just that a signature is not required. And currently, there are two criteria, 46117C1, for which there's no equivalent FDA regulation, and 46117C2, which has an equivalent FDA regulation. And this one, so C1 is, if it's the only record that would link the subject to the data, and the principal risk would be getting a signature on the consent document. So examples of this would be possible jeopardy that would be caused by interviewing people about sexual behavior, about criminal activity, about things that might affect their reputation or et cetera. Then it could be drug addiction, child abuse. That if those people could be linked to their responses, they would be unwilling to participate because that would create risk for them, then you're permitted, provided the research is otherwise minimal risk, to waive the requirement for documentation of consent. Now, the second category under 117C2, and also permitted for the FDA, is if the research is no more than minimal risk and it involves no procedure for which you'd need written consent outside of the research. When you go to the doctor's office, he takes a history, a physical, obtains blood sample, measures you, weighs you, does whatever, looks in your eyes, ears, examines your eyes, get an MRI scan, get a CT scan, whatever you do, if you don't need written consent in the clinical care situation, then you don't need written consent to have the same procedure as part of research. During our AHRP examination, one of the examiners felt that because the subject was in front of the investigator, that even though it met this criteria, that we should get written consent, and we should have done it, which we didn't require it. But if the regulation permits a waiver, then it's up to the IRB to allow that waiver, provided the investigator requests it. And this is part of the issue, I think, with the current common rule. It's a lack of concrete examples in good guidance documents that explain how these things actually play out. And much of what the NPRN is trying to do could have been achieved, I think, with guidance to explain and get how these things could have gone down. So the IRB may require an information sheet when they waive the requirement of documentation of consent, so there's something to give somebody. Many IRBs just make it a consent form. We've had many other formats of information sheets. Here's two of them. They tend to be simpler and more what people would actually want to know about the study. And people, our investigators, when they do this, often put pictures in there and other things that would have been nice in the consent form, which they just never seem to do. So the NPRN makes a change to the regulation to facilitate the recruitment of prospective research subjects and create a more flexible rules for documenting informed consent for certain populations. The NPRN retains the current waiver criteria, but it renumbers them. So they're now, instead of C1 and C2, the numbering is different. And it adds a new waiver category for subjects who are members of distinct cultural groups or community. And it also adds a reminder that research subject to regulation by the FDA is excluded from this, in other words, formerly 117C1, unless authorized by the FDA under 109C1, which is the equivalent of C2. So it is allowed for certain cultural groups to waive the requirement if signing documents is not the norm and the research presents no more than minimal risk, and there are appropriate alternate mechanisms for documenting that informed consent took place. Namely, Bobby Smith agreed to take part in the research, put it in the subject's record. And in addition, you have to include in your study documentation, basically your files that probably would be submitted to the IRB as part of your request, why this group should not have to sign consent. Now, how this differs from 117C2 eludes me entirely. What would be permissible under this category that would not be permissible under the current 117C2? I don't understand. I'd like to see minimal risk for which you need to have signed consent for a procedure that would not also be eligible under the prior requirement. But this is, so whether this could have been handled with guidance or this required a new requirement, that'll be up to the final rule. Now, the waiver of informed consent, the IRB can waive informed consent entirely, provided the research is no more than minimal risk, if the waiver or alteration will not adversely affect the rights and welfare of subjects, and this is not clearly understood by any of us, but institutions use data and specimens collected for a lot of other purposes besides research, for quality improvement, for feedback, for all kinds of other purposes, billing. And so if that data is already being collected, and then presumably then people's rights and welfare aren't being violated by using it for research purposes. And then the research could not practicably be carried out without the waiver or alteration, and I've highlighted practically because the NPRN includes some clarification about what that means. And then wherever appropriate, subjects will be provided with additional pertinent information ever. And this is rarely something that happens. It's limited usually to prospective studies. So OHRP has added an interpretation of practicably in which they say they've agreed with SACHARP's interpretation, and then they reiterate the requirements from SACHARP that scientific validity would be compromised if consent were required. For example, there's research involving the incidence of a certain problem. Well, if you don't have everybody who has the problem and everybody who was at risk of having the problem, in other words, the numerator and denominator, then you won't get valid results. And so if the research would be scientifically invalid, then you can can't practice. If you required written informed consent or verbal informed consent, then that is part of means by practicably. Ethical concerns would be raised. If you were to notify thousands of people that they were now research participants, then that might raise some issues. There's a scientific and ethically justifiable rationale where it could not be conducted with a population from whom consent could be obtained. So if there's a population that could consent, and so that this is just an easy way out rather than a requirement, in other words, you're just trying to take a shortcut, then that would not fit within practicably. And so at the end, practicably would not be determined solely by considerations of convenience, cost, or speed. On the other hand, it says solely. I mean, so for me, considerations of convenience, cost, or speed are a consideration, but just not solely. If you have 20 years of data about an important medical question in clinical records and you can answer a question now, or you would have to consent people and wait 20 years into the future to answer the question, I think that that would be an issue where it would be important to answer the question now rather than later. So how would the NPRN change the regulations Well, it prioritizes the use of non-identifiable data or specimens, which seems to be a bit of a non sequitur because non-identifiable specimen is a human subject, so it's not clear what that means. It adds new restrictions for waiver of consent for use of biospecimens. It adds a new criteria for waiver or alteration of consent for biospecimens, and it clarifies and revises the waiver requirement for recruitment or screening. So the numbering is changed in terms of the waiver requirements, and there are criteria that now mimics HIPAA's wording. So it prioritizes the use of non-identifiable data or specimens by saying, if the research involves accessing or using identifiable specimens or identifiable information, the research could not practicably be carried out without accessing and using those identifiers. So why do you need to have this identified? Why couldn't somebody else provide you with a non-identifiable data set, non-identifiable specimens? Why do you need those identifiers? For example, you need to match the specimens with information in their medical record, so that you have to provide a rationale. Since we currently have to apply HIPAA's requirements to the common rule, in effect, this already applies because it's a requirement for covered entities. So we have to apply both criteria, but it sort of harmonizes now with HIPAA. So if you're going to apply a waiver of consent for use of biospecimens, the NPRN anticipates that this will be rare. And for research secondary uses of biospecimens, I would agree it should be rare because people will have had the opportunity to consent. But in the clinical situation, that may be more problematic for clinically obtained specimens. But there must be a compelling scientific reason. I have 20 years of neuroblastoma specimens that I'd like to use, and I can't get consent from all those people. Research cannot be conducted with other specimens for which the consent was or could be obtained. So that is much more problematic for the clinical specimens, but it has to do with other issues like namely broad consent and how practicable that will actually be. So the IRB cannot waive informed consent when an individual declines broad consent. That sounds great, and it certainly is ideal that we can't waive it if somebody's previously done it. That's respectful. Investigators should currently, we require them to keep track of these decisions. But now, if the specimen is in a pathology or some other location, and a person has had participated in 3 different studies and has had 20 different clinical encounters and has had an opportunity to sign broad consent multiple times, then they might have given different decisions based on the different point in time. So we not only have to track what somebody has said in a research setting, but in the clinical setting, they may have made multiple different decisions at multiple different times. So then which specimens apply to which? This is going to be an enormously complicated matter to keep track of to which decision, which consent applies to which specimen. And I don't look forward to implementing this. Now, this is actually a very positive thing in the NPRN. So you can tell my biases here from the presentation. Currently, the FDA considers somebody to be a human subject if they receive a test article. So they have a different definition of what makes somebody a human subject than the common rule. And as a result, they don't consider somebody a human subject if you record their names or get information from them to find out if they might be eligible for a study. How old are you? Do you have diabetes? Et cetera, et cetera. That doesn't make them a human subject. But under the current common rule, if you record somebody's name or you ask them any questions to find out if they're eligible for a study, you must either obtain their informed consent or the IRB must issue a waiver. So if an investigator goes through his records and tries to identify the people who are 45 to 65 who have diabetes and high blood pressure, recording their names makes them a subject, even though they may not have submitted a study yet, and they're doing this work under a work preparatory to research. So it gets a little bit confusing what to do there. But if it's part of the work submitted to the IRB must either require informed consent or it must waive informed consent. And under this, under the proposed rule, they're sort of harmonizing with the FDA. Namely, the IRB may now approve a research proposal in which investigators obtained through oral or written communication or by accessing records identifiable private information without individuals' informed consent for the purposes of screening, not just recruiting, but screening, recruiting, or determining the eligibility of prospective subjects. So you can go through your records today to see who's going to come to the clinic tomorrow and see if they would be somebody you'd want to approach, and you can write it down, and then you don't need a waiver of consent to do that. So I think that this is a very positive step and gets rid of an impediment or an unnecessary regulatory burden. What's not in the NPRN that I think should be in the NPRN regarding waivers? The FDA has something called EFIC, the exception from informed consent for emergency research. That is either approvable under, that's under FDA's regulations 21 CFR 50.24, which allows, it defines a whole set of procedures that allows the IRB to waive informed consent for emergency research. Now, in the Federal Register, in the same issue as the FDA publishing this rule, was a OHRP, which actually was OPRR at the time, published their criteria, which basically were the same, that they would approve this. And that then became an OPR memo, I think October 31st, 1996, and that's what's generally referred to as the rules. And it says in that memo that if the research would have been approvable under the FDA's regulations, namely it's the NIH is sponsoring a drug trial, and therefore it's regulated by the FDA, then it's permissible for the IRB to waive consent even though it's federally funded, or it meets the same criteria as enumerated in the Federal Register, which basically are for non-FDA regulated research. It has to follow the same criteria. So why this has not been added to the regulation and codified in regulation is left to a memo that's hard to access. I don't understand. I think it's an opportunity to include this information in our current regulations so that we harmonize with the FDA and with what appears to be OHRP's current thinking. So I think that's all I have to say about this. I welcome any questions.
Any questions from the audience? We have one coming.
Hi, I'm Mariette from University of Arizona. Something you didn't touch on in your presentation, but maybe for Totten as well as for you, this concept of oral permission for access to data, because the NPRM has separated data from specimens. So I'm having a hard time justifying when would we use a waiver of consent for data with the new proposal that you don't need it for screening or for enrolling, looking at recruitment for. Thank you. But then there's, I can't remember if it's excluded or exempt now, this concept of give oral permission for access to information. How do those two play together moving forward?
I think it's, if the object was simplicity, I think it hasn't hit the mark. And I think it's confusing for all of us. And the reason biospecimens are excluded is because there's genetic information. Now, you and I can be identified with fairly high degree of certainty from our birth date and our zip code, two elements of a limited data set. We can be identified by the pattern of our CBC results, provided somebody already has it. You can be identified from your genetic information, provided somebody already has it. So the NPRN, to me, and if your whole genome data is in your medical record, that's not covered. It's only the specimen itself. So why the data derived from biospecimens isn't as protected as the specimens themselves, I don't understand. I mean, I didn't write it, so I don't have to defend it. But I don't understand those questions either. To me, this all could have been much more simplified, but it's by making specimens, rather than the data derived from specimens separate, I don't understand that at all.
Totten, do you have anything to add?
Well, just in response to your first question, you mentioned exemptions, and I just want to point out that there's only one category of exempt research which would require consent, and that is for the collection, storage, and maintenance for secondary, future, unspecified research use of identifiable information. And in that case, there would be a broad consent template that would be provided. And to the other point about why data generated from biospecimens would not be subject to some of the same requirements that biospecimens would be. I think by requiring that biospecimens be obtained with consent, that would address to some extent the possibility that data generated from those biospecimens could be, or that data could be generated from those biospecimens for use in research.
So the majority of specimens that are collected are for clinical care. Dwarfs what's collected for research. When I signed my HIPAA release for my last surgery, it was presented to me on a single piece of paper in 8-point type after they'd taken away my glasses. And less than 10 feet away from me was a gentleman who was forced to discuss his sexually infected diseases, transmitted diseases, his drug abuse, and alcohol problems, within earshot of about 15 people. To me, broad consent is a fig leaf covering up the fiction that people will provide any reasonable consent, that it'll be administered by the same people who get HIPAA authorization, namely secretaries and people in busy surroundings. And the notion that it will be cheap to implement tracking these things I'm bewildered by how anybody thinks this will be inexpensive. This will be an enormous undertaking, or people will just simply not use the data or specimens, which will have a appalling effect on the conduct of research using clinically available specimens. So if the issue is that people could be identified, high-powered computers can identify all of us from our Google searches. For $39.95, I can find out almost anything I want to know about you. So society is moving towards less privacy and confidentiality, and here we're moving towards more restriction about sequences of A's and G's and T's. So I don't understand it.
I have a question from live streaming. Why is the issue of the term human subjects not being addressed in the NPRM? Why is the term volunteer not acceptable?
So I think this relates to a question of terminology, which is, human subjects perhaps has a connotation that people are the subject of research rather than participants in it. If this is something that you feel should, change over time, or perhaps even be reflected in the regulatory text itself, I would just encourage you to submit a comment to that effect.
Excellent. Another question specifically for you. What guidance can be provided on electronic consent that can incorporate images or videos into the consent and include comprehension questions to assess patient understanding?
Well, that's permitted right now. There's nothing that prohibits doing those things.
Yeah, I don't think the NPRM would, is actually proposing to change anything or to prohibit the use of that kind of media.
Great. From the audience? Dr. Reader?
What is this? Yeah, I wrestle with this goes back to the last question about the volunteer or subject. I wrestle with that all the time. I can't come up with a better term. The term volunteer implies that it is indeed they are a volunteer and there is no and then the term participant, I think all parties are participants in the process.
And remember that some people are participating without their knowledge under a waiver of consent. So they're not volunteers, and they're not participating with their knowledge. So I think one is what term is in the regulation, and what terms should be used in a consent form when addressing the people who you hope will take part are two separate issues. So I'm fine with human subjects, and sometimes the FDA and their regulations say that that something is an equivalent term. You know, like this means the same as that, and I think that would be fine to just put in the synonyms. But how we address people when we talk to them and how we refer to them in the regulation maybe can be different. They don't have to be the same.
There's got to be one more question out there while they finish setting up lunch. Anyone? Any final parting words of wisdom from you, Dr. Schreiner?
I think it's impossible for any of our organizations to respond to all 88 questions. I think that each organization should focus on the things that would improve things the most for them and provide positive feedback for those things, and provide feedback about the things that are most problematic and suggest alternatives. I think it's not going to be enough just to complain about it, but suggesting alternatives might help as well.
That's great feedback. Well, thank you for joining us. And so the plan is to take just a short break, 20 minutes, to grab a box lunch, use the restroom, and then we're going to return and get right back to it. So those of you who are live streaming, I hope you can grab your own lunch. We'll see you back here at 12:15. Thanks very much. I heard you've been doing the road show. Hi, everyone. We're going to go live in just maybe a couple seconds. Are we live? Oh, wow, we're live already. Well, we're going to do some housekeeping as far as getting all of our speakers to come up. So the format of the next session is that we're going to do some presentation. We're going to have Amy Schwarzhoff give the first 30-minute presentation, and then we're going to do sort of a little Q&A or sort of a panel. So I'm hoping that we can have Jerry come up, and Ross as well would be great, and Taunton is going to join us again, which should be great. So again, we're going to hold questions till the end, and then we can have an interactive discussion, but we're going to start with an overview of the changes, and then we'll hear 3 different perspectives on them. All right, so I think we found everyone. You can snuggle in. I'm camping out over here with all my items. Great, so Amy Schwarzhoff is the Director of Human Subjects Research at CHOP, where she leads all aspects of the IRB office and its support services, including regulatory requirements, maintaining the AHHRP accreditation, meeting Research Institute metrics, managing the IRB review process, managing required regulatory and hospital documentation. She's an experienced consultant for medical schools, universities, hospitals, and law firms, addressing concerns related to the IRB and Human Research Protections Program. She has previous experience as an IRB operations director for multiple types of IRBs. She earned her Bachelor of Science in Psychology, Family Systems, and Child Development at Texas State University, and her MBA at the University of Maryland, University College. So as a reminder, we'll save questions for the end, and I welcome Amy to the podium.
Thank you. Now, you said 30 minutes for the presentation. My understanding is I've prepared for about 10 or 15, so we'll adjust as we need to.
Yes, 10 minutes.
Great. So we went over the changes earlier today, but since we're going to be talking about different perspectives related to this information, we thought it'd be good to kind of go over them again specifically so that we can kind of lay the groundwork for the additional discussions. Related to the NPRM, there were a number of proposed changes related to consents. So there was the organization and presentation of information included in the consent documents and the process to facilitate prospective subjects' decisions about whether to participate in the research. And that's what we're focusing on now. But just as a reminder, some of the other proposed changes related to consents coming out of the NPRM include the elements of consent, basic and additional, so the 3 additional elements that were discussed earlier, the broad consent to the storage or maintenance for secondary research use of biospecimens and identifiable private information, and then the attendant changes to the waiver and alteration of consent. So again, we're focusing just on the first one, and it's probably one of the less controversial proposed changes coming out of the NPRM. So we're going to talk about the goal of the NPRM that was stated in the publications that came out in September. We're going to talk a little bit about the proposed rule. We're going to talk about what would change according to this rule, and then we'll talk about different points of view coming from participants, researchers, and the IRB and institution. So the NPRM's goal specifically for this change is to facilitate prospective subjects' decisions about whether or not to participate in the research study, and therefore enhancing autonomy. Some of the concerns that were expressed in the publication included that consent forms have become a tool to protect institutions instead of a tool for communicating important information to prospective subjects. Another concern expressed was that consent forms function as a sales tool to help pull people into the research as opposed to providing genuine information that a potential subject would need in making their decision. And then finally, the additional concern that was referenced was that these consent forms are too lengthy and complex, adversely affecting people's ability to really understand what the risks and potential benefits are from the research. So before we talk about the new requirements, just a reminder about what the current requirements are. And this is separate from the basic and additional elements of informed consent. So the current requirements indicate that investigators must ensure that subjects' informed consent is obtained from subjects or their legally authorized representatives. Nothing new. Provide the prospective subject sufficient opportunity to consider whether they want to participate in the research, and we need to make sure that we're minimizing any coercion or undue influence. We need to make sure that the information is provided in a language that's understandable to the subject, that there's no exculpatory language or releases from liability, and we need to make sure we're including the basic and additional elements. And they've been silent on the organization of how the informed consent is written or presented to potential subjects. So the proposal, the new language to the introductory text, so that the section that I just read, this new information would be embedded within that same information. So they're emphasizing the need to first provide essential information that a reasonable person, that word again, or that term again, would want to know in order to make the informed decision. It requires that information be presented in sufficient detail regarding the specifics of the study. Information must be organized and presented in a way that does not merely provide a list of isolated facts, but needs to be organized so that it facilitates understanding. And investigators must present first the information required in this section, the basic and additional elements, before they give any other information. The consent document must include elements of a consent that were required by the rule, and anything else they say specifically should be in an appendix, which is new and not something that had been provided in the current rule. And when HIPAA authorization is required and it's part of the consent process, that needs to be in the main body of the informed consent. HIPAA authorization language cannot be in the appendix associated with the document. So OHRP is planning to put out some guidance to help investigators create and IRBs to approve informed consent forms so that they're in compliance with these new requirements. But just a reminder of the changes. So the new language would strengthen the informed consent requirements to make sure that most appropriate language is presented first. New language would clarify when HIPAA authorization is combined, that needs to be in the main body of the informed consent. And again, the Secretary is going to provide guidance in the future about how to organize the consent forms. So now I think we're going to talk about the different perspectives.
Thank you, Amy. So we're going to have three perspectives. We're going to have the participant perspective and the researcher perspective. So we're going to start with Jerry. So Jerry is the Director of Patient Initiatives at Healthy Vibe, LLC. She is also the founder of Partners in Research and speaks publicly on the topic of clinical trial participation. Through her work at Partners in Research, she is dedicated to raising awareness about clinical trials. By sharing experiences and providing information, she hopes to remove the anxiety over the unknown that patients might feel when considering participation. In her role at Healthy Vibe, Jerry helps patients contribute to the design of clinical trials, resulting in faster, more effective, and less expensive research and development. The company is guided by the premise that patients should play a more instrumental and active role in clinical studies before they're designed and conducted and throughout the entire patient journey. Welcome, Jerry.
Thank you. First, I would like to thank the NIH and Vanderbilt University for inviting me to represent the patient voice on the proposed changes to the informed consent. Special thanks to Tara Helmer for getting me here. She did a phenomenal job bringing it all together. So, a little bit about me and why I was invited to speak. I was diagnosed with MS in 1999, and I spent 8 years on a therapy that wasn't working for me. I was sick and tired of being sick all the time, and I was contemplating suicide. But in 2007, I found a new neurologist who suggested joining a clinical trial. But I'm a hypochondriac, and I felt compelled to search for any information I could find about what being in a trial was like. The fact that I found nothing didn't dissuade me from joining, but it's why I ultimately decided to blog my own study. My blog then caught the eye of pharma and resulted in what has become an ongoing conversation with researchers about the patient experience in clinical trials. Joining that study changed my life so profoundly and improved my quality of life so much that now I'm dedicated to raising awareness about the need for volunteers and to help make the entire trial experience more patient-friendly through my work at Healthy Vibe. So, going back to my very first trial, because I've taken part in several to date, let's take a look at my original informed consent. You can see from the highlighted sections that it wasn't very patient-friendly. Right off the bat, the title of the document has me identified as a research subject, which we've already discussed in the comments. But to me, I feel that's dehumanizing and dismissive of the importance of my role. Then along the left side, you see words that aren't used in everyday conversation. Words like protocol, sponsor, and investigator all have quite different meanings to the average person than they do when used in research. There are 15 pages to this informed consent, with each one just as indigestible as the one before. Where it talks about the number of visits further into the document, it says X number of visits, but those may be broken up into several visits according to scheduling availability. So, well, which is it? 10 visits or maybe 30 visits? Because a 2-hour trip takes a huge chunk of my time and money. I know researchers love to use words like randomization. In the world of science, it has a very succinct meaning, but when a patient's first visit is defined by a word that sounds scary, maybe it's time to rethink that. The phrase randomly assigned to one of the study groups may not be as sexy, but at least it conveys the meaning more clearly. This informed consent also placed enormous focus on the possible risks. Granted, there were many known risks for the medication, but the possible benefits were buried back in the back in only 3 short paragraphs. And that basically told me that there were no promises or guarantees. Even the signature line refers to me as a subject. But that was a different time, and I forgive whoever wrote that informed consent. I think going forward, we're going to do a much better job, and that's why I'm here today. I did an informal poll when I found out I was going to be here on social media to find out what other people thought was important about the proposed changes, and if they had a voice in the matter, what would they say? So a lot of them felt very strongly that patients need to be included, real patients, in the writing of the informed consent, to let them help define what is most important to include up front. I mean, saying you need to include the most important things to make the decision, well, who decides that? I think patients should have an enormous say. So next, don't assume Flesch Kincaid knows best. They also want to see it simplified in lay language, but don't assume that running it through a grade level checker is adequate, because you could use a term like rescue therapy, which, for instance, may score appropriately, but when the patient reads that, they're scared, thinking they're going to need to be rescued. In reality, maybe all you meant by that was Tylenol. And if that's what you mean, then say that. Using language that can't be so easily misconstrued. Don't use acronyms. I know people in government and academia are fond of these shortcuts, but as far as layman terms are concerned, if you have to resort to acronyms, perhaps you should rethink how you word what it stands for to begin with. I can't tell you how many times, ever since I was invited here to speak today, I've had to look up what NPRM means. And to me, this, I live and breathe research from a patient perspective, and if it's that hard for me to figure this stuff out, just imagine how scary it is and confusing to the people that are faced with life and death decisions at the lowest, most vulnerable points in their life. And you can see that, it's been 8 years since my first trial, and I'm still touched by this. It was a really scary time. So regional and demographic patient considerations, going back to consulting patients for deciding which things in the informed consent are most important. Be sure to work with patients who match the demographic of the population you intend to study. Explain the freedom to leave the study right up front. I know we talked about that earlier. But most people instinctively recognize a contract when they see one. And in most cases, if you sign one, you're bound by those terms. And so patients need to know that they have the right to leave at any time for any reason, or even for no reason at all. They don't have to explain themselves. They can walk away. Explain the role of the IRB better. I still, sitting here among you, and I know many of you are probably members of IRBs, I don't really have a clue what that means. Patients in the study need to know who is looking out for their best interests and how to contact them if the need should arise. Simply defining it as institutional review board isn't enough. That doesn't tell them anything. They need to know that if they ever feel that they're being unethically treated, that they have someone to turn to as a matter of recourse. And the appendices that we're talking about, that's new to me, as I guess it is to all the rest of us, but I feel a big red flag went up when I saw that you could put whatever else you needed to include in the appendices. And if we're not clear on who's deciding what's important to put up front, we at least need to make sure that the appendices are just as clearly written and available to the patient. That was one of my questions I had earlier that I was too afraid to ask, but when the patient is presented with the informed consent, I hope that they also receive everything included in the appendices. So how the informed consent is delivered to the patient, what it looks like, is a whole other story. I've been a printer and graphic artist all my life, and so I know the power of design to clearly convey messaging. And like a commenter said earlier, the few changes they made by including graphs, and it just made things a lot more clear for the patient. So here's my short wish list for the informed consent version 2.0. Break the contents up into sections that are easy to absorb, because it's hard to read long paragraphs of text, especially when you're distraught. Use bold headers to easily differentiate. This document isn't a one-time read. You can bet the patient, like I did, will be knocking on the door of every family member and friend, especially if they have any medical background, in order to get their take on this. Make it easy for them to navigate the document and share their concerns with others. Use a large font with more line spacing. 10-point times New Roman has got to go. It's just not user-friendly, and that's all I'm saying about that. Graphics and illustrations, use them where appropriate. If you have a good spot for graphics in the document, whether it's a graph showing comparative likelihood of side effects or an image of somebody undergoing one of the tests they might have, a picture is worth 1,000 words. Collaborate with patients to design standardized templates for use. Involving patients in the design process can help you figure out what's layman-friendly and patient-friendly. Include a glossary of terms. For the terminology you have to include, which can't be further simplified, include a glossary and be able to look up, so they're able to look up terms and refer back to them. It's essential. And don't be boring, strive for engaging. So that brings me to my final slide, and I think this is the perfect forum for making a plea on behalf of the e-consent, and I'd like you to give my best reasoning on why it's so attractive. You can adjust typefaces and sizes to be more accessible, as I heard someone speaking earlier about the typeface was too small. Even my mother, who just turned 92 last week, is reading her books on a Kindle now because she's got issues with her eyesight, and being able to create a custom user experience to suit her need is everything. Multimedia, using videos or graphics to demonstrate procedures. The way we digest information as a society is rapidly evolving. I don't think there's very many among us who still get the majority of our daily news from a newspaper. We're digital, and it's time that that is reflected in the informed consent. By going digital, the ability to explain your study to a potential participant is opened wide up. If you need to explain an MRI, why not just show a video of a patient undergoing one? Or maybe if they could even make a MRI-friendly GoPro, you could have that video from the patient perspective. Remember that glossary I said you need? What if you could hover over a term and have access to a definition, a video, audio, or any other type of supporting information? And email copies for patients. You might argue what happens when the patient wants to refer to it later. Well, send them an email copy that's always available, it's portable, it's shareable, it's accessible, and it's eco-friendly. And I feel strongly that if a e-consent is thoughtfully designed, it can become a study-long guide. Imagine your informed consent being a document that acts like a virtual guide, walking the patient through every step of the journey, explaining what comes next, what to expect, and how to prepare. I think a lot of times that patients drop out of studies because they didn't realize how time-consuming it would be, what a huge impact it would have on their life, or what the procedures or tests would really be like. Addressing these issues would be so much easier in a dynamic multimedia presentation rather than on paper. Ideally, the informed consent could connect the patient to their clinical trial data later on, and they could find out the study of the status drug and even what the brand name it receives when it's approved. To be truly patient-centric, the informed consent will need to be not only shorter and in layman's terms. I think the way the guidance is currently written in the NPRM is not enough, in my opinion. It's a start, but if you at least consider some of the ideas I've presented today, it could be so much more and become a welcome and inviting doorway to participation, and rather than a scary and confusing maze that it currently is. Thank you.
Thank you, Jerry. We'll hear more from you in a minute during the panel. Next, I want to introduce our researcher perspective. We have Dr. Ross McKinney. He is the director of the Trent Center for Bioethics, Humanities, and History of Medicine, and a professor of pediatric infectious diseases at Duke. Dr. McKinney's research is the antiretroviral treatment. Whoa, that was a big one. Thank you. Treatment of HIV-infected children. And he has additionally published articles on the natural history and pathogenesis of pediatric HIV disease. Dr. McKinney has chaired the Pediatric AIDS Clinical Trials Group, Protocol 300, a large 471 patient study of, you're killing me here, sir, with your bio, of lots of big words. As the director of the Trent Center for Bioethics, Humanities, and History of Medicine in the Duke University School of Medicine, his current research involves the ethics of medical research with a particular focus on conflict of interest and on the informed consent process. He earned his medical degree from the University of Rochester School of Medicine and Dentistry. Welcome. Thank you.
Well, one of the things I appreciate is I was actually asked to present opinions and reactions. So you're going to get opinions and reactions as part of this. I hope the facts are correct, but you're going to get opinions and reactions to elements of the proposal. So my goal as an investigator is to have people enrolling in the study that I am leading because they want to be in the study. I don't want to sell them on being on the study. I want them to make a good, reasoned decision to participate. That's what informed consent should be about. So my highest value as an investigator is very similar to the value that a patient participant would want to have. I only want you in because you understand the study and you want to participate. People who understand a study are more likely to see it through to the end because they aren't surprised. And people who understand the study are more likely to adhere to the medication, to adhere to the visit schedule, to participate actively, knowing why they are part of it. And for that to happen, they must understand at the point of informed consent what they are being asked to do. Our current system does not do that. Modern informed consent basically has become the mortgage document or the EULA. And for those of you, we're not supposed to use them, but a EULA is an end-user licensing agreement. It's what you signed when you got your Windows 10. Those 93 pages of little teeny font that look like this, that at the end you went, oh, hell, just check. And this is what modern informed consent has become. We are taking a binary decision with an end. I want my software or I don't want my software. I want the money from my mortgage or I want the money from my mortgage. And you are layering on layer and layer and layer of information which fundamentally does not alter that binary decision that you either want the software or you don't. And in fact, most people who participate in research have actually made the decision before they come to have the discussion. And we layer on much information which does not facilitate the decision-making process, and we should be much more focused and clear. And the key principle that comes out of these giant documents that we now use, like the mortgage, like the EULA, is gotcha. Because you just skip all of the process. You kind of go to the end and say, I don't even want to think about it. And when you hand somebody a 38-page consent document to participate in a clinical trial for a new cancer drug, they're not going to go through all 38 pages, in spite of what you, in your heart of hearts, may believe as an IRB member. It isn't going to happen, and we shouldn't be asking it to happen. We should be learning how to ask people and give them the information they need to make a decision. And so I would argue that this system of using these giant documents values autonomy because people get to make a decision, but it shows no respect for persons. And what we were urged to do in Belmont was respect for persons. And autonomy is one element of that respect. But when you present information to people that they cannot understand in a format that they will not bother to go through, you are not respecting persons. The NPRM, as best I can see it, does nothing to further our respect for persons. It is critical that we get better understanding of what informed consent means. We need more empirical research. We need to understand what kinds of information actually affects when people make a decision to participate or not. But what has happened now is we look at isolated things, like, for example, the number of subjects who are going to be in the study. And we say, oh, that's a useful thing to know. It is also useful to know that Prague is the capital of the Slav, or of the Czech Republic, but it is not meaningful to the decision that I'm about to make. The decision to participate or not is about me. It is not necessarily about the number, the N, in the study, and it is now going to be an additional required element. I do not think that that is a benefit that's going to come out of this process. So what we have is a series of isolated decisions about information, and we keep stacking it into an ever and ever taller stack, and the NPRM just adds things onto the pile without improving understanding. The question really being asked in informed consent is, do you want to participate in the research? And so we have lots of clauses. They are collectively weighed against a global binary objective, yes, no, I want to participate. I want you to know what you need to know to participate or not. And so that matters. But it's a binary decision, and we're treating it as if every little element could be the basis for somebody to decide, yet it almost never is. And by providing all of that information, we obscure what matters. So finding a way to focus it, and I have to say, I think electronic consent documents are exactly the kind of thing that can be used to focus the process, and we'll talk more about that. So the product of the current system is informed consent documents which are reviewed by the IRBs. And the members of the IRB are often the only end users to actually read through the entire document. A 38-page informed consent, probably the person who wrote it and the IRB are the only two people who will have read it. So again, this is pure paternalism. The IRB is making the decision, and the potential participant is looking at this thing and going, good God, well, I hope somebody's looked at it. I assume, like I always do when I sign my mortgage, that some lawyer, this is standard language. I don't know what's in there. I don't know what I'm signing for. I just want the mortgage. And I think the same thing is happening in our informed consent process, and this bothers me as a researcher. So the NPRM does acknowledge my concern. The goal of the proposed changes to the informed consent form and process is to facilitate prospective subjects' decision about whether to participate or not participate in a research study, thereby enhancing autonomy. Exactly right. Exactly right. Unfortunately, it's a little bit like nuclear weapons being named the peacemaker. It is right, but what follows does not necessarily match with the aspiration. I find that nothing in the NPRM, there's no additions. Now, there's one thing I will say, there's a caveat to that. I do like the idea of the two-part form. And I've been part of a group who's been working on that two-part form for a while. And in fact, it's being presented tomorrow in a webinar. So the Clinical Trials Transformation Initiative, CITI, has been working on this with patient advocates, and we'll be presenting that, the product of our work, tomorrow at noon. But the notion is that you shouldn't have to put everything in front of the line. That what should be in front of the line between what is the consent document that is read carefully and what is in the more appendiceal information, that line should be able to be set by the IRB relative to what risks are involved in the study, not an arbitrary laundry list which may or may not be relevant to the people who are deciding to participate. So in addition to the previously 8 required elements, now up to 9, there are 9 additional elements to use, and several of these will be likely to be required, and I don't think they help people make decisions. I think they're more clutter. So things like the number of subjects in the trial is clutter. Things like the commercial use statement. Most people are not going to decide whether to participate in a research study or not on the basis of whether they're going to have their sample used commercially or whether they're going to get money from it. They're not going to go out and shop for a study that does intend to use. And in fact, how many samples have ever been used for commercial purpose? Very, very few. So this is much ado about nothing and just adds clutter and doesn't help the process. And finally, the late recontact expectations. Another thing that's not going to help you decide whether to participate or not. It belongs in an appendix. It doesn't belong in stuff you must discuss to decide whether to participate in the research or not. And conceptually, the broad consent, the idea is to make less work for IRBs with biospecimen issues. But as proposed, I view it as a real risk-benefit mismatch. You're going to make people go through this consent process and give them a lot of information. In most cases, they don't care about because the specimens have already been drawn or going to be drawn, and it doesn't matter that much to people once they know it's going to be used for a research purpose. And I'm willing to accept the broad consent, but then the tracking. You know, if you do it today in pathology, your next study is at UNC, your next study is at Wake Forest. Do we get to use the specimens from Wake Forest, but not the ones from Duke? What about the ones at UNC? If I said no at Duke, does that mean at Wake Forest it's going to be a mess. The tracking's going to be a mess. I don't think logistically it works, and I don't think conceptually it improves the protection of human subjects. What should have been done? What should the NPRM have done? Because we should give positive suggestions. And I think that we should have, as in our objective, to provide adequate information in a dispassionate style so that a reasoned decision about participation can be made. We don't want a sales pitch. I don't want to fool somebody into going into my study. I don't want partial disclosure of the expectations of the study, because that's a gotcha on me, and that's not fair. So I want a fair disposition of what the study's going to look like. So why don't we use the NPRM to set that kind of goal? To talk about what we need to communicate so that people make decisions. We should be steering with guidances, not regulations. We should have a broader, let the IRBs work to achieve this end and not give a laundry list that in fact isn't even a good laundry list. Why don't we encourage, why didn't the NPRM encourage electronic consent documents? A standard video the IRB could review that could be fair and complete as needed, with further information by hyperlinks that allows people to get more information where they need it, and an electronic schedule so they can see what's going to be expected of them. And you could even test for comprehension if you use that kind of a strategy, which would be really nice, because that's been one of our goals of consent that we don't get at all with our 38-page consent documents. The emphasis should have been on the process too, and not on the document. And once again, they are pounding on the document, making it longer. And that should not have been with the NPRM. It had a chance to do things right, and it did not exercise it. So to me, as a researcher, the NPRM is both an enormous lost opportunity to improve the informed consent process and a significant step backwards in terms of the length of what it is expecting. I, as an investigator, first and foremost want participants in my study who truly want to be there for as much as I can control the right reasons. And I do not believe that the NPRM moves us in the right direction.
Okay, so I'm back. So now that gave you the basic information, we've heard from a researcher and a subject advocate, patient advocate, a patient in research. Thought it would be good to talk about the IRB's perspective. So we talked about NPRM's goals. From the IRB's perspective, my perspective, and the perspective of the IRB I work with, we are always working on simplifying the informed consent document. It's always been too long, and if you've submitted a study to CHOP that has an IRB, an informed consent for IRB approval, you've frequently, more than not, received suggested edits to that informed consent. As was stated earlier, we're one of the groups that actually goes through and looks at all of the pages of the informed consent. And they're just too long, as everybody agrees. So we work constantly to find ways to simplify the language, simplify the information that only is necessary, that's not superfluous. So we focus a lot on the reading level. The goal is 6th to 8th grade, but that's very difficult to achieve. We are also looking at formatting. Can we use bullets? Can we use tables? Can we increase the margin, or the margins? Can we increase the font size? Make it easier to read, in addition to using language that is not overly technical or overly scientific, so that when we're communicating the information, hopefully we can provide information that's understandable to the subject and their families. would love ways to minimize the complexity of the HIPAA authorization language. When you look at an informed consent compared to an informed consent and authorization form, the reading level goes sky high. The comprehension, I'm sure, drops dramatically. We still have to continue to include it because we are a covered entity, as I'm sure a number of you are, and need to make sure that we're covering HIPAA authorization. We would love to have some guidance on construction, so that researchers can develop informed consents that are easier to understand, so that sponsors understand our point of view a little bit better when they're constructing the studies, or the informed consents that a number of investigators are going to use. Well, the NPRN said in one of their concerns, or in one of the stated concerns, was that they've become a tool to protect institutions instead of a tool to communicate information. My experience has been, it's not necessarily the institution that's being protected. A lot of times it's the industry sponsor. There is a lot of language in there that frequently we will ask to have removed because it doesn't aid in the process of obtaining informed consent or providing informed consent. There might be language that an institution does require, but I think the majority of it does not come from the IRB. It's coming from other stakeholders in the research process. I was very encouraged to see the use of appendix in the proposed rule. We, as an IRB, have talked a number of times about, well, if we could just pull this information out, put it in the appendix so it's still available for the families, for the subjects, the participants, the volunteers to access, not only now during the informed consent process, but later after they've gone home and are having conversations with their family members. The fact that the appendix is there is very encouraging. So I'd love to be able to see, or I'd love for us to start being able to implement this so that when studies, research is combined with clinical care, we can pull out the risks associated with clinical care, the risks that subjects will be exposed to anyway, whether they're in the research or not. Let's put that in the appendix. Let's put the procedures that they will be exposed to in the study, but that are clinical procedures. Let's put that in the appendix. So we're focusing on, you're in the research study, this is what's going to be different for you because you're in a research study than what you would get in clinical care. So this really helps, I think will help facilitate that process. I hope we will get a lot of adoption about this. My concern, though, is how are we going to implement this? Another acronym, I'm sorry about that, the International Conference on Harmonization. This is some guidance that's provided to researchers who conduct international research. If you want to state that your research is ICH compliant, you have additional elements that have to be in the informed consent. So when we are organizing the informed consent and we're providing suggestions about what needs to be in the consent and what needs to be in the appendix, do the subject responsibilities, if they're in the appendix, is this still ICH compliant? Or will this cause problems? Do we have to include this still in the informed consent before the signature lines? Important potential risks and benefits from alternatives to participation is another ICH required element. Again, where does this have to be in order to be ICH compliant and compliant with the regulations? So guidance on how this will be treated, I think, will be critical before IRBs feel comfortable in recommending or requiring information be pulled out of the consent form and be put in the appendix associated with the informed consent form. Also, requirements or FDA regulations. It'll be good when FDA comes out with their opinions on what comes out in the rulemaking to help us understand what the expectation is from that perspective. And for those institutions that are accredited, their human research protections programs are accredited by the Association for the Accreditation of Research Protections Programs. This group goes above and beyond the regulations, and at times it may seem like it's a judgment call whether we're meeting a standard or not. It will be good to hear from that group about how they expect these new presentation requirements to be presented. So the IRB challenge, I think, is that there are a number of items, as was pointed out earlier, that we have to include in the informed consent. So we've got all of the basic elements, we've got the applicable additional elements, and we've got a number of stakeholders who each think different parts are the most important. So we heard earlier that from a researcher perspective, that the number of subjects in the informed consent may not be meaningful information. But if I'm asking, or if I'm being asked to put my 5-year-old daughter in a research study, and I see that there are going to be 10 other participants in this research versus 500 other participants in this research, that may mean something to me, especially if it's biomedical, if it's a more risky research study, that may be important to me. So each stakeholder in the research endeavor have different opinions about what's essential. And for us to identify those and make reasonable approaches to this and divide the informed consent form into the main document and the appendix, I think is going to take some time. The guidance, the one question regarding this section that the NPRN included was asking for suggestions on what should be included in that guidance. How can we help the researchers, the IRBs, with this? And I think until we have that guidance, it's going to be difficult. One of the other changes in the NPRM is the posting of informed consent forms, finalized informed consent forms after enrollment is closed. For those of us who have lots of time on our hand to go and look through those, we might be able to identify some really good examples, but that's going to take a while before there's a good library available, and that's going to also take a lot of time to go through. So I think this is going to just be a struggle that we're all dealing with in this process. So just a reminder, these are the basic elements of informed consent. These are the additional elements of informed consent. So it's a pretty long document already, just containing the list of required documents. What we have on our website is a guidance, kind of an educational tool that we provide to our investigators to help them understand what information is required because of the regulations, and it helps them understand why our template and the information. So if we look at this, you'll see there's a little legend, and I apologize, it's a very small print, but it kind of helps the investigator identify what are the required elements. And you'll see that on this document, most of this meets the requirements for the basic elements. Here's another example. Again, the risks are, you would list them if appropriate. But again, if we have pregnancy and blood tests, we need to have some basic information to outline what it is. And another example. So most of the documents, most of the informed consents are trying to put in lay terms what the basic and additional elements of our informed consent are. So to be able to pull out any extra information, put it in appendices, I don't know how much that's going to shorten the document or enhance comprehension for subjects. It would be good if we could get some guidance on who has the ultimate authority over the informed consent document. We have sponsors who provide templates to their researchers. The researchers will put in CHOP information. I need to give CHOP's contact information for questions. And I need to give our IRB number. And I need to include the investigator's name and contact information. They'll submit that to the IRB. The IRB spends a lot of time trying to put it in lay language, trying to simplify it, trying to make it as short as possible, as reasonable as possible, but then we hear that the sponsor won't accept it. Well, those sections can't be changed. We can't take out any of those risks, even those risks might be related to clinical care, or they may not be reasonable, what reasonable people would understand or care about. So, but we know that our investigators are in a bind, and if they can't remove those sections because the sponsor won't let them, And then the IRB says, well, we can't approve that document when you have what is an investigator to do? So there have been times where, after going back and forth multiple times, we've said, okay, it's not exculpatory. We're not waiving any rights. It's not factually incorrect. It doesn't aid in comprehension, but maybe we can live with it at this time. I think if we were to get more guidance, more help with identifying who has the ultimate authority, I think that might help a little bit with this conflict that our researchers are in. Thank you.
So we're going to take some questions, and maybe, Amy, I'll have you sort of decide who should answer them, or do we have questions from the audience, or maybe some online folks? Questions from the audience?
Do you think that having the single IRB would be one way to increase the leverage the IRB has with the sponsor? Because what's currently happening is they are gaming the individual site investigators against each other, in a sense. And will your IRB cave before the next one so that I can be part of the study? So you're under pressure.
And another IRB has approved that already.
Right. So is this one of the places that having a single IRB might, in fact, improve our leverage and ability to define who controls the ultimate document?
I think that's a great question. Is this on? Okay, thank you. I think that's a fabulous question. There are a number of issues related to a single IRB that I won't necessarily go into right now, but I do think if you do have one IRB that is the IRB for all of the investigators, that may help a little bit with this. And it might also encourage a little bit more communication across the different groups. I think that has a potential. It's a great question. Mark?
It's a terrific panel. It was great to, I think all of you had a lot which I agreed with tremendously. I think this NPRN, as Ross said, is focused a lot on the document. And from research, we know when comparing complicated forms to simplified forms, that on 14-point scales of comprehension, people who get simplified forms improve their understanding by 1 point on the scale. So they go from 7 to 8 to 8 to 9. In other words, they still don't understand a lot. And so I think all of this emphasis that maybe we ought to just use a short form for everybody and have more detailed discussion about the things that people want to know about. That in Europe, our chair at the committee at our IRB right now is from Germany. She said most of the consent forms are 2 or 3 pages. So are we documenting that we agreed to take part, or are we including everything that might happen from now for the next 5 years? And if it's everything for the next 5 years, no one will read it, and no one will remember it, and no one will understand it even if they do read it.
And the other part to that I would agree particularly with is that you have individual stakeholders. And so this is a point you raised. Individual stakeholders may care about some point, but put that in the appendix so that that person can find it. Don't obscure it. Make it easily found. Index it. But don't force everybody to hear it, because I don't think most people, much of the information they won't care about. So you want it available. You're not trying to hide things, but you also want to focus on the risks and benefits that and costs and the voluntary nature of the research. And that's where the focus of the in front of the line should be.
Jerry, do you have any additional comments? No, okay.
And I have a follow-up. I think it's related to that question. I'd like to hear all of your perspectives about the IRB process as far as I work for the Philadelphia Health Department IRB, and we get a lot of mental health studies. And some investigators have done the process so that they are literally reading. It's simplified, but they are literally reading to the participant and to facilitate comprehension and questions and an in-depth discussion about what's required, what's going to happen. I'd like to hear all your perspectives on that process, making that more of a standard.
I'll go ahead and start. I think each research study is completely different. It might be that sometimes giving the informed consent to the potential participant, so that they can read it at their own pace, go back, cross-reference, may be appropriate. There might be times where having a member of the study team read it, but allowing for the participant to have some time alone to look at it. It will all depend, I think, on the type of research, but as long as we're ensuring that the information is communicated appropriately, that there is time to look at the document, to consider it, to ask the questions, I think that's a little bit more important from my perspective.
So I'd just like to say, are you talking about mental health research? Is that what the question was about? Sorry.
No, it's okay. I just use that as one example.
Okay.
But I'm talking across board. We do all kinds of research.
Well, I think especially in the area of mental health, there should be some sort of an independent advocate that is assigned to the patient to help guide them through the process and be there with them to sort of facilitate the discussion. And that could be true for anybody in a study, that if there was some, I mean, family and friends are great, but they're really overprotective a lot of times, and they would opt for you not to join, or they would advocate for, weighing the pros and cons. So I think there needs to be somebody appointed that's not necessarily, somebody that doesn't have a stake in it.
And I think, Jerry, you're getting right to one of the key points, which is really what the informed consent process is about: trust. Are you giving the person the kind of information that they should trust you? And will they trust you in the future? Because I want them to stick with the study all the way through. And if there's distrust from the beginning because something that has been said or it's been presented in some way that seemed obscure, so they didn't get it, you've lost the trust. And you've lost, it may be semi-transparent, but we really need to be working on processes that build trust. And so with the kind of story you're talking about, using an advocate is one strategy, but making sure that it's somebody that individual trusts. And I have to say, one of the mistakes that I think IRBs make, we are so concerned about the therapeutic misconception that we remove the person who the patient, the potential subject, has chosen as their trusted care provider, their doctor, for example, and remove them from the consent process for fear of the therapeutic misconception. I actually think people are more bothered by having somebody they don't know, so have no trust in, coming in to do the consent process, than they would be with somebody they do already have a relationship with, as long as the person is, playing within certain rules. So they are not selling the study, which is why I like things like an electronic consent with a presentation, so you can answer questions, but everybody's seeing the same presentation. It's constant, and it's not a sales job anymore. It's the information that you need to know. So you can have the trusted person there sitting there answering the questions, but here's the real facts just to make sure everybody knows.
So I think this just gets back to the fact that we're talking about the process, who's involved in the process, and not the form, not this 20-page documents that we're going to sign ultimately.
And they have spent the entire thing on making the form longer and not improving the process, this is a huge lost opportunity.
Well, that's a perfect time just to remind you that none of these comments are being collected and submitted on our behalf. So we need to all take the action to post an official comment to the docket. So don't forget that piece. So from our streaming folks, we have a question to Taunton. Clarify if recruiting includes contacting candidate subjects for the time requirement that you spoke about.
Can you repeat the last part about the time
So it says,
requirement?
clarify if recruiting includes contacting candidate subjects for the time requirement Taunton spoke on.
Well, I'm not sure which time requirement they're referring to.
I think it was Mark's. It was Mark's comment about the recruitment and the ability to involve.
I'm getting for the posting.
Yeah,
The
that's-
consent form? Oh, of posting
for-
it 60 days after the trial has
Oh,
finished recruiting? Is that what we're talking
Oh, is
about?
it posting?
That after,
Oh,
okay, the
okay.
posting
That
requirement?
sounds correct. Right, so there's a posting or a requirement that the informed consent that was used in a study be posted online in a database that will be developed 60 days after the end of the recruitment to that trial, or to that study, rather.
So did you answer the piece about, is recruiting included in contacting in that?
I'm not entirely sure what
What we're
that's
getting at
referring
that.
to,
I
so.
think it means at the end of enrollment.
Yeah,
The
absolutely.
last subject is enrolled is the end of recruiting. So it has nothing to do with recruitment in terms of identifying.
Yeah, so the way I interpreted
I
it
think
was
that's
that
correct.
after enrollment is closed,
right,
we have to,
right.
60 days
Right.
to post.
And this is one of those things that you can and perhaps should comment on, because I'm sure you're all, having looked at these long documents, we're now going to have a giant website with lots and lots and lots of them, and with every IRB making sure that you track down that those are being posted, because your AHRP accreditation is going to depend on you making sure that all of your documents are being posted in a timely fashion.
I know, my understanding is that clinicaltrials.gov, the reporting requirements are pretty onerous, and now we're adding this on top of
Yeah.
it.
And
For the benefit, I think, is still under discussion.
vanishingly small, some of us would perceive.
Live question?
Hello. Just to clarify on the time of posting for 60 days after recruitment ends, OHRP clarified at Primer this last week that it was only one consent form for a multi-site study, and it could be the sponsor that could be the one that actually posts it, and you also don't need to post every amendment made to that particular consent document.
So another question that came in through a streaming person is, why can't we learn from the many informed consent reforms that groups like NCI have taken? Implementation is the issue. I'm not sure if that's a comment
Right.
or a question. Sounds more like a comment.
It sounds like a comment to me, unless anyone else has anything to add.
We actually have a paper that's been submitted trying to analyze why we have not succeeded with various proposals to make informed consent better. And our bottom line is, we haven't figured out how to measure what good consent is.
Right.
And so it's really hard to hold things to a standard when you really don't know what the standard is.
Right.
Dr. Reed?
If the posting requirement holds, I don't understand the utility of why it would be posted after enrollment is closed. It would seem that the immediate utility would be for candidate subjects to be aware of this study and this opportunity.
My understanding is that it's transparency is part of the goal. But I completely agree. In some ways, it seems like it's a tool for lawyers or other individuals to go through looking for informed consents and finding fault and questioning after the fact.
I would just like to say that I hope that it becomes a tool for learning how to really create a good informed consent, because there are going to be all kinds of examples. Why can't you just see it as bragging rights?
I think that's a great point, and I would love, my concern from an IRB perspective is who's going to have the time to go through and read all of these in order to find the very good examples.
Well, maybe there could be some sort of tagging ability when you're uploading it for different things that you've incorporated into your informed consent, and then you can search by tags for, ones that use graphics or.
I also worry that it is document-centric, and if you're going to get away from documents, this is a very document-centric strategy. So again, it's not antediluvian, but it's close.
So related to that, for Taunton, why create a new database? Why wouldn't this posting of consent documents on clinicaltrials.gov be used instead?
Well, if that's a database that you think that should be linked to this or should be the primary database for this, I would just suggest that you submit a comment.
Any other comments? Here we have one coming.
comment. So if the goal is transparency, one fear is how to keep it up to date. Because if there's just a one-time posting, how, participants might be getting incorrect information about a consent form in that location.
And I don't think it's going to be current. I completely agree. If a study is up and running and then they have to amend the study for whatever reason after enrollment is closed, that information is not going to be there. And again, the information is not going to be necessarily available to those participants who might be interested in being in the research if it's not posted until after enrollment is closed. So, yeah.
This is, I just perceive it to be meaningless information being gathered with good intent, but not of value, and will create a significant work burden that does not balance against the benefit that will be achieved.
So, Dr. McKinney, this is in regards to the importance of trust. A watcher says, I was surprised to hear you say including potential commercial interest in consent form is clutter. Do you not see that transparency as part of trust building? I'd be curious to hear your thoughts as well as others on the panel.
I didn't, as far as I know, say commercial. Oh, it's commercialization of the samples, which is the worry, the Henrietta Lacks theory of commercial use, that you're going to convert everything into. So commercial use of research, I think you should say who the sponsor is. They are developing a drug. I think that should be part of the discussion so people know. That's part of trust and transparency. But the issue of samples being converted like into monoclonal antibody generating cells or cell lines, it is such a rare event that you could probably put the list of all the times it's occurred with any commercial significance on half of one page from 1952 when the HeLa cells were derived. So it's a waste of time, and I think it is Henrietta Lacks that's pushed this, and I think it's exaggerated concern over something that's of minimal significance.
Do you have thoughts on that, Amy?
Well, and I think the difference between the informed consent and the appendices, this might be an area that we could include the information, but it doesn't necessarily need to be one of those critical points that a participant or potential participant needs to have in front of them before they make the decision.
And I agree 100%. It's a perfectly reasonable thing to put in the appendix. It's you might want to know this, but it's not likely to be something that's actually going to affect your decision to participate or not. And that's what the line should be. The things that a reasonable person should be using to make a decision to participate in front of the line, the appendices get the things that are nice to know.
Mm-hmm. Do you have any comments, Terry?
No, I agree with both of them.
There we go. That's great. There was one other comment from a viewer just supporting this idea that clinicaltrials.gov should be where the consent forms are posted and be done with it. But again, viewers, we encourage you to submit to the docket so they hear that loud and clear. Do we have some more questions from the audience? We have about 10 or 15 more minutes. Anything else? Any final comments from our panelists?
No, I like the idea of including that glossary that Jerry talked about earlier in the appendices, again, to help aid in the process. And, they talked about that. What was that again? Especially for later conversations, later when we're going back and reminding ourselves what was said during that conversation.
And I also wanted to say that I think it's really what you said about how you structure, when you do have a document, even if it's a short one, how you structure it can affect the readability to a great degree. Mm-hmm. And it's not just Flesch Kincaid, it's big letters, it's organization, it's graphs and charts that give you flow charts. We found flow charts were really useful to explain complicated studies. Like this might start to happen here, so just be aware and ask questions. Those are things that would be very useful to have in front of the line.
I've heard Flesch Kincaid mentioned a couple of times now, and there's research to show that in terms of health literacy, it overestimates or underestimates overestimates the simplicity. It's 1 or 2 grade levels lower than the actual readability of documents, and that the best reading tool for documents is SMOG, which is the Simplified Measure of Gobbledygook. And all of these are available free online, sites like storytools.com, but at least it's a good start. And there are other tools as well that'll identify. One is called Hemingway. It's a little app that you can install on your computer, and Ernest, being famous for writing short, pithy sentences, I think it tells you sentence by sentence what you can, gives you suggestions for fixing it. But the NPRN doesn't mention the use of plain language, and plain language is an accepted term in government documents. It's in HIPAA, and there's even a plainlanguage.gov site, and I think that that would be a common denominator for ensuring readability, is to ensure things were written in plain language.
Well, and I think that really the best gauge of readability is to pose a potential informed consent to a group of actual patients. I mean, who can tell you better that whether or not they understand it than the people that you're going to be studying themselves? It seems like a no-brainer.
A lot of our studies, and I'm talking from the IRB perspective now, it's hard to bring the readability level down because sometimes the investigator will say, in this patient population, they already know what they're going through. So even though this doesn't seem like lay language, they understand it. And it's very hard. So especially in a lot of our studies that study rheumatological diseases, it goes way over my head. But in that patient population, they understand it. So it's not so simple just to say, put it in lay language, bring it down, because it may not seem like it's down, but they know. And we do a lot of trials where we're trying out new infusion therapies or new drugs for different indications, and it's just a comment. It's difficult to bring it down all the way, all the time.
Well, that's exactly my point, too, is that you don't know what patients are capable of comprehending if they're living with these diseases day in, day out. They educate themselves about it, so they may know more than you give them credit for, while they may totally miss the mark and not understand something that you thought was lay language, like rescue therapy.
As a footnote, another alternative that we used for a while, he's now retired, but we hired a child psychologist who had been editing children's textbooks. And he knew what a sixth grade reading level looked like. I mean, that was his job. And so he went through and made sure that our consents were at a sixth grade reading level. So there are people out there that you can find who do this for a living. That's another possibility. I agree with the patients, but you may choose the patients who you communicate with most often, who often are going to be the ones who are already sort of bought in. So it's got to be careful.
Yeah, that's good. I have a question from a viewer. It says, in terms of therapeutic misconception and the physician as consenting study team member, should we not consider that the participant might see the physician as recommending a particular intervention as a recommendation for treatment? There is research to support this, and I do think that we might consider having some other team member have that discussion. What is the panel's perspective on this?
Jerry, do you mind taking that to start off with?
Well, I would say, in my own case, in my very first clinical trial, I discussed this with my brand new neurologist. On the one hand, I trusted him because he was a neurologist and he was specializing in MS. On the other hand, I had no history with him, but I did feel like I wanted a neurologist to explain a neurological clinical trial. So I felt more comfortable with him, and I had to sort of build the relationship with the study coordinator who brought in the actual document to have me sign and everything. But you know, I didn't feel coerced at all. I felt like I could ask anything. In fact, I did ask a lot of questions, and one of them was the fact that this was not a placebo-controlled study. It was a comparator trial. So my options at the time, if I didn't join the study, I was probably going to choose the comparator anyway. So it was more of, in my case, it was unique in that, you know, it's either take a chance on this or do this anyway. So
You are weighing two different values. So on the one hand, you have the value that the patient is getting from working with somebody they trust, and the other one is the potential that that trusted individual could be misleading. And that's where the concern is, or that the person will misread this person who is acting as a researcher, and that they are, in fact, they look like your physician, but they're acting as a researcher. So that's the worry of the therapeutic misconception. But your other value is the trust. And does the person who is giving or trying to obtain consent acting in a way that they justify that trust? Are they giving a fair representation? And so part of the informed consent process as it currently exists is to make sure that somebody isn't being sold to get into the study. That's why we go through this whole thing. And so we're already starting to build protections that tilt away from the concern. And yes, there is the potential for therapeutic misconception, but I'd say the worry over that is more than counterbalanced in most cases, but not all, by having somebody in whom the person has trust acting in a trustworthy way.
I think this gets back to we're focusing on the process, not the document, and the proposed regulations are focusing on the document again. A lot of times we see that the coordinators, other members of the study team are involved in that informed consent process, and sometimes we have to mandate that a physician member or the principal investigator be part of that, or at least available. Again, it depends on the research, the institution. Everyone has their own opinions. I've had principal investigators come to me and say, oh, well, I try and have these conversations with my patients, but they just say, whatever you want, doc, whatever you want, where do I sign? So it's kind of, okay, well, we need to engage a process, and if you're not sure what to do in those cases, well, you need to ask them about their understanding about what's going to happen in the research, so you're forcing that dialogue. But I've seen less of requiring that the PI be part of that process or not be part of that process unless there's maybe a conflict of interest management plan in place.
The other thing I actually do like, one of my radical beliefs is that the IRB should review the consent process more than the document, and that there should be expectations which could include questions about comprehension as part of the consent process. And I personally think that should be part of the routine that the IRB approves, but that's radical.
Oh, I would argue that not necessarily. I've seen a lot of IRBs who are asking who's going to be involved in that process. What does that process look like in addition to that form? So again, every IRB is a little different and each institution is a little different.
So a viewer is going back to the appendices that we talked about earlier. They write, appendices pass the current problems on to each investigator. What guidance will be included?
I'm not sure that there will be any guidance in terms of what specific elements should be included in appendices. One can point to the elements of consent that are stipulated by 116A, B, and C as being the information that will have to be included up front, ahead of the appendices. But beyond that, I'm not sure that we can necessarily expect guidance that would detail what should happen in the appendix, other than the sort of general exhortation that's included in 116 that the consent process and materials have to be what a reasonable person would need to know.
Great.
And just the one question regarding presentation of the informed consent was regarding what guidance are we looking for? What topics do we want to see in the guidance that's going to be produced?
Great. Going back to the lay language, comprehension takes more than language level. It is about the ability to stay focused on the content. Perhaps we are not stressing enough the importance of how engaging the forms or content are.
Mm-hmm. Yeah, I think that goes back to the way it's organized, if there are pictures, if there are tables, what information is in there. And again, if we can make it electronic, I think all the better.
Yeah, definitely. I agree wholeheartedly, and that was pretty much the focus of a third of my talk, so I'm behind that.
Great. Any other final comments, questions from the audience? Any final comments from the panelists? Taunton, anything from you? Great. Well, we are going to take a 10-minute break. I see some goodies potentially over there. If you need another sandwich, grab one. We'll meet back here. It's 1:35, so let's meet back here at 1:45, and we'll get started again. And thank you so much to our panelists. everyone. I'm back on now. Welcome back. I hope you all grabbed a drink and a cookie and you're ready to go. We are going to tackle our last formal presentation entitled Establishing Standards for Safeguards. We have Maureen Smith with us today. She is an assistant professor of medicine at Northwestern University. She's director of the New Gene Biobank and the Center for Genetic Medicine and co-PI for the Northwestern site of the eMERGE Consortia. She has extensive experience in obtaining informed consent for genetic testing and research and developing educational materials on genetic topics for public and professional audiences. She earned her Bachelor of Science degree in 1983 from the University of California at Irvine and a Master of Science degree in Human Genetics from Sarah Lawrence College in 1987. You are putting your age in there. I love it. You are all about transparency. This is great. She is board certified in genetic counseling by the American Board of Medical Genetics and the American Board of Genetic Counseling and a licensed genetic counselor in the state of Illinois. She has over 14 years of genetic counseling experience in the areas of prenatal, pediatric, adult, and cancer genetics. Maureen worked for private companies developing genetic educational materials and solutions for the delivery of genetic services. She has been awarded several clinical research grants and has authored numerous scientific articles and abstracts, as well as articles for the public. Her main research interests are in the professional advancement and training of genetic counselors, the integration of genetics and medical care, and the education of health professionals and the public. Let's welcome Maureen.
Okay, I'm going to tackle this topic of standards and safeguards for participant data and specimens in research. I do have to admit, and I think you can see from my bio, that I am a director for a biobank, and so I obviously have some perspective about the importance of these kinds of databases and specimens for research, and I'm also an investigator. And I'll also admit that the NPRM was quite challenging for me to review, and also presented some challenges in terms of its vagueness, and hopefully I can, I'm not alone, but I can point out some of those that were difficult for me. So I hope to talk a little bit about some of the rationale for the changes, actually from my perspective as a geneticist and genetic counselor, and some of the biobank research, and also discuss some of the current safeguards that are in place now, as well as compare and contrast those a little bit with the proposed changes, and then summarize and talk about some of my perspective and maybe some of the things that might be missing. So why are these changes important now? And I think the creation of collections which store biospecimens and associated data, such as health, sociodemographic data, as well as genetic information, that these kinds of banks or repositories are being created across the country and across the world, and they are becoming more and more important in research. And many of these are created to store specimens and data indefinitely, and for a variety of uses. And so obviously they've become very important in research. And also the increasing use of large databases that store data that's derived from biospecimens, so it's data only instead of data and biospecimens. And so these are increasingly being used as repositories for all kinds of data. And in addition, the greater use of genetic technologies in research, particularly those involving whole genome sequencing, which has the ability to potentially be an identifier, with caveats to that, of course. And then the ability to merge all these data sets from many different places, data sets that are available online, as simple as voting registration, as well as medical claims data, as well as electronic health record data. So we have data all over the place about us. And so the idea that we can bring some of those together, triangulate them, look at health data from lots of different perspectives, as well as incorporating biospecimen data into that I think has raised awareness and concerns. So, in thinking about doing this presentation, I wanted to think about what the public concerns are. And I think, in general, that the public is concerned about the privacy and confidentiality of their data. And while they want to participate, they don't want, or they want to understand what risks and what those generally are. And some they're willing to take on, and some they're not. They just need to understand what those risks are. I think there's so many examples of data breaches that we hear about all the time. I always worry when I am starting a study or starting recruitment for a study, if there's been a recent data breach at Target or whatever company out there, then people are not going to want to enroll in my study because a lot of it will involve collecting data and storing it. And so I think that these are realities that we live in today that people are just generally concerned. And finally, has been brought up before, I think one of the most important things is, and it's been proven in many research studies, that trust in institutions that conduct research, as well as the investigators themselves, is a major factor in people participating in research. And I think that this is the major issue that we have to focus on with the NPRM, is how we continue, or how we can gain trust of participants who we would like to be in our research or who are already participating in our research. So I included these definitions, which I did because I was hoping there would be public involved in looking at the NPRM. I think many of us are aware of the differences between privacy and confidentiality, and but I think these terms are often confused, and I wanted to make sure that we are all talking about the same things. And certainly in terms of privacy, it's just defined in terms of having control over the extent, timing, and circumstances of sharing oneself with others. And that's an important thing for a research participant in terms of the consent process, and knowing and being able to think about what they're participating in. And confidentiality pertains to the treatment of the information that someone has actually disclosed in a relationship of trust. There's that word again, and with the expectation that it will not be divulged to others in ways that are inconsistent with the understanding of the original disclosure. And so I think those are really important just to remember what we're talking about today. So from my point of view, the IRB provides review and oversight of research on identifiable data and biospecimens for the adequacy to protect privacy of research participants and confidentiality of their private information. And I think this is what we rely on currently as, and I think what most participants, they know that someone has reviewed their consent form, someone has reviewed their study, and as has already been mentioned today, that sometimes these consent forms and other documents are so confusing that people do hope that someone else has reviewed them and at least approved them. And up to this time, in the review of research, de-identified data has not really been considered human subjects research and has been excluded from IRB oversight. So current protections that are available now include, besides the IRB, we also have, most institutions have, are protecting participants' confidentiality of their information through the Health Insurance Portability and Accountability Act, or excuse me, Health Information. That was a little slip. In 1996. And this establishes national standards to protect individuals' medical records and other personal health information. And this act requires specific measures to safeguard electronic health information to ensure its confidentiality, integrity, and security. And HIPAA applies to covered entities, health plans, healthcare clearinghouses, and those healthcare providers that conduct healthcare transactions electronically, and also as well as their business associates who interact with those covered entities. So in this way, participant data is covered, and there are some assurances to protecting that data. However, HIPAA doesn't cover biospecimens in any form. So some of the proposed safeguards, it's mentioned to set universal standards for privacy and confidentiality protections for research. And this somewhat relieves IRBs from this type of oversight, who often, as they mention in the NPRM, don't have particular expertise in this area. And I think that, they may be responding to the technical issues with the very large data sets that are becoming more in use, that IT technology is just confusing, complicated, and that rather than having this be the purview of the IRB, that it should be, that universal standards can be set that would be able to protect participants. And currently, under the Common Rule, IRBs must review each individual study's protection plan to determine whether it's adequate with respect to the informational risks of that study. And so the NPRM would basically remove that from the IRB's purview. So they propose that the standards would include security safeguards to assure that access to physical biospecimens or data is limited only to those who need access for research purposes. And the standards would also assure that access to electronic information is only authorized for appropriate use. And I think this is very similar to safeguards we have through HIPAA. Safeguards would assure that information and biospecimens posing informational risk to subjects would be protected according to appropriate standards. And this, they say that they create information privacy protections that would apply to research that's calibrated to the level of identifiability and sensitivity of the information being collected. And this adds greater oversight of the uses of biospecimens in general. So consent requirements for leftover surgical and clinical care specimens would now, even if they're de-identified, would come under oversight and require consent. And that also considers de-identified biospecimens, as I mentioned, to fall under this definition of human subjects research. So the proposed safeguards allows institutions and investigators to choose which set of security standards to use. So this is proposed that standards would be developed and be published by the Secretary of Health and Human Services. So a list of specific measures that an institution or investigator can use to meet the requirements would be published. First, these would be circulated to other agencies for input, and then a final list would be published. And of course, we have not seen this list in the NPRM. I think that an issue about this is that I would expect by this time that list would have been published. We had the ANPRM since 2011, so there's been a long time to think about this, and so I would have liked to actually see in this proposed rule that we actually have that list and have something to react to. Alternatively, institutions and investigators that are currently complying with HIPAA will satisfy the requirements. And it also mentions that those who are not required to comply with HIPAA can choose to do so, to comply with the requirements. And so I think this gives sort of these alternatives. And it suggests a very great reliance on HIPAA in general. So just to review briefly, just the HIPAA safeguards, in addition to defining what is sort of protected health information and what's considered identifiable, has this list of a number of things that institutions or covered entities have to do in order to meet HIPAA requirements. And these are administrative, physical, and technical. And these are no small things for an institution to put together and to monitor. They require performing risk analysis regularly, assessing risks to protected health information, monitoring security procedures, designating a security official at an institution, also physical requirements that limit access to facilities. So all those kinds of key cards and things that we've seen come into place at our institutions are the kinds of things that would be required, as well as workstation and all our devices being secured. Access, some of the technical requirements are around access to authorized personnel, implementing hardware and software to monitor access to PHI, and any implementing policies and procedures to ensure that there's no alterations of PHI, that it's not destroyed, as well as implementing technical security measures that guard against unauthorized access to electronic PHI. So lots of passwords and other kinds of monitoring systems, as well as procedures in place that are necessary in order to comply with HIPAA. So some of the safeguards around secondary research are spelled out in regarding biospecimens or identifiable private information that's obtained for research purposes and when it's shared with others. And it's limited to the 4 conditions that I've listed here for human subject research that's regulated under the common rules, so meaning that it requires consent, and this would include de-identified biospecimens, that the research is for public health purposes, for any lawful purpose, and the consent of the subject has been obtained, or for other research purposes if the institution or investigator has obtained adequate assurances that the recipient investigator will implement and maintain the level of safeguards required by this provision and the research has been approved by an IRB or is exempt. So it's basically a written agreement that the recipient investigator will abide by the consent and the safeguards that have been required of it. So in general, I think from my understanding and in my humble opinion, I think that the changes proposed in the NPRM relax oversight regarding the use of data from research. It increases reliance on HIPAA security rules. There's less reliance on IRB oversight, specifically due to a number of exemptions and exclusions. And there's increased opportunities for foregoing consent and research because of the multiple exclusions and exemptions. And a number of these exemptions and exclusions you've heard about earlier, these include low-risk research and collection of publicly available data, as well as secondary research on non-identified specimens that generate information that's already been known about a person. So there's a variety of situations where data is exempt. So the NPRM proposes to develop a universal set of standards to help assure privacy and confidentiality protections for research participants. And as I've mentioned, these have not yet been published, and we don't know how closely they'll follow HIPAA standards with administrative, technical, and physical requirements, and how onerous or unonerous they may be on in institutions. I think they add, the changes add greater oversight over the uses of biospecimens in general, the consent requirements for leftover surgical and clinical care specimens in particular. It considers de-identified biospecimens to fall under the definitions of human subjects research. And I think in general, this is going to be something that could possibly inhibit research in many ways. In my opinion, also, de-identified biospecimens in and of themselves don't really pose increased risk to participants. So some of the questions regarding the safeguards, as I've mentioned, should these be as restrictive as HIPAA? And should the particular information security measures be required for certain types of information or research activities? And I think, we don't yet know what measures and for what types of information or research, and specifically the discussion about the safeguards being calibrated to the sensitivity of the information to be collected. And I think that's what the NPRM tried to get at many of the exemptions and exclusions. However, I'm not really clear on how far those will go. I'm concerned about heightened restrictions around doing certain types of research, such as mental health, looking at using mental health data, which could potentially receive higher levels of security as they do now. And I think in many ways this prohibits research from taking place. So I am concerned about us having less opportunities for research, having more restrictions on using safeguards that are implemented without the ability, without whether or not they make sense actually to participants and investigators. And I think the proposed limitations on secondary research are can be more restrictive, and particularly if secondary research involves de-identified biospecimens. There's much less oversight over data in general, and I think that the additional purposes for which sharing of biospecimens or identifiable private information should be permitted, as well as will the proposed changes decrease the ability to perform large-scale research? And I think that they do. I think there is a certain amount of prohibitions against information, and particularly where these involve biospecimens. And I think this is probably the biggest concern I have, that this is overly restrictive. And so with that, I think that my concerns are that we certainly want to engender trust in participants and make sure that we're communicating information about our research, that we are transparent, and I think there's many ways to do that. But I think the idea that of considering biospecimens so much different from data, because after all, the data is derived from the biospecimens, and if data is identifiable, it is has the potential to be as risky as a biospecimen in any sense. So I will end with that and look forward to comments.
Great. Do we have any questions for Maureen? Yes.
This is Amy Schwartzoff. A few of us at my institution have talked about maybe imposing fines for attempts to re-identify data with specimens instead of the restrictions that are currently imposed with the proposed rulemaking. What are your comments about that?
It should be.
I actually think that would be a really important thing to do. I've looked at this for a while regarding data sharing and possible breaches, and I think it's a very important issue, and I think it would assure the public, too, that we were really serious about protecting their privacy. And I think it's, from my focus groups and other interactions that I've had with participants, this would be really critical to gaining their trust.
Any other questions? We would love to invite the other speakers from today to come up and join us and get the dialogue going, get some more conversation going. Maybe some more questions will come up for Maureen as well. Hoping you all have some questions for us or something you want to hash through a little more before we depart, so you can get your thoughts around what kind of comments you want to officially submit to the docket.
Come on, Amy, don't leave us up here alone.
And Jerry, maybe if you want to sit at your seat, we could give you a microphone at your seat if you'd prefer to stay where you are. Okay, great.
You are Mark.
Now we are all here, so what kind of questions might you come up with? Here's a very long one. Woo. All right, number 1. Subsequent use of data for research already having been collected for something other than research should follow the same rules. With exclusions of genome-wide sequencing under the current proposed changes, I am not certain that this was followed. That is a comment. Anyone want to weigh in on that? Okay.
That's the way it seems to me, that we're protecting the specimen, but not the data derived from the specimen. And I'm not sure why specimens that might be used, like for microbiome research, deserve more protection than genetic information from a whole genome sequencing. It's not clear to me at all.
And the specimen itself, there is no value to the specimen. It's the data from the specimen.
Right.
Totten?
Yeah, I would just respond that, and I think I've said this before, but in order to generate data from a specimen for research, it would actually require that consent have been obtained for the use of that specimen. Now, if the data was generated for clinical purposes and was de-identified, it would remain outside the rule. But if the data was identifiable, then it would still require consent to be used, or I'm sorry, to be obtained.
So is that parallel then to, let's say, just clinical data that's captured and the rules governing that use and subsequent use?
Well, are you referring to HIPAA, or do you just mean in general for clinical data that falls outside of HIPAA and how that's used in the common rule?
So,
yes,
Taunton,
the latter.
Can I
Okay.
just interject? If that specimen is no longer a specimen but has been turned into data, so for clinical purposes, someone has whole genome sequencing, this rule does not protect the results of the use of that specimen. It only protects it if there's tissue left over and now an investigator would like to now do genome sequencing. So why is the research use of a formerly clinical specimen more sensitive than the results of a clinical test done on a clinical specimen?
And
the whole thing is that people might be re-identified. We can all be re-identified. We know that now. On Google, Ross was re-identified on a Google search, or somebody was re-identified on a Google search, which, I mean, you should tell the story.
Well, it was the story that they told at Primer, where they worked backwards from it was an AOL search, but it was, they looked at somebody's searches of a whole bunch of things, and they found, for example, first thing they looked up was dog pees all over the house. And then they figured I was a Manchester Terrier that was peeing all over the house. And then some point later, they looked for a restaurant in like Lillington, Connecticut. And it turns out Lillington, Connecticut, I don't know if it was Lillington, Connecticut, but somewhere like that, 5,000 people. And the combination of Manchester Terrier and Lillington, Connecticut led to Thelma Arnold, who was recognized, and this was put in the New York Times, and said, we can find you because big data contains all sorts of clues that you might not recognize. And, your search is this long, and they just found these two little things, but those two, the overlap of the Venn diagram is so small, it's one person. So privacy is increasingly a futile pursuit.
And we are moving against the trend. The people can search through our data and re-identify us much more easily than they can from a biospecimen. A genetic information is like a fingerprint. If you already have a copy in the FBI database, then you can identify somebody from a fingerprint. So if you don't already have their genetic information, then the new set of genetic information is suspect unknown.
And as a patient, I would just like to interject here and ask the question, if I sign a broad consent and allow you to do research and collect data on my specimen, how do I then revoke that if I change my mind? Because if I'm in a clinical trial, I can drop out. Mm-hmm. How do I undo? That's like unringing a bell.
I think that's going to depend on the institution that obtains the broad consent from you. What processes do they have in place, if they have any, if there's some link to it?
I mean, usually for most biobanks, they contain the information or the specimen is coded so that they can link back, because for the most part, a specimen without any kind of data is pretty useless. So for the most part, they can destroy the sample and stop it from being used in further research. But for research that's already out there, or for databases that information that's derived from that specimen might already be in, it will stay there. But for the most part, none of those databases are going to contain identifiable information. For the most part.
Now, just one comment for pediatric research. If we have samples from pediatric patients, once they turn 18, if we still want to use them, we have to get the subject's consent. And the only way to do that is to go back with identifiers.
And as a pediatric researcher, I can tell you it can sometimes be really hard to track down where the kids have moved, because kids and families move a lot. And so this will be a really hard thing to, will be a real barrier to progress in the field.
I would just like to remind everybody that a required element of broad consent is that there has to be the ability for a participant to withdraw their consent, both for the collection and, of their data and specimens for the time that they had previously agreed to, but also that any specimens or data that can be retrieved and destroyed would be, although there would be an acknowledgement in that consent as well, that would not, it would not necessarily be possible to retrieve and withdraw specimens and data that have been used for research already.
So I can't remember the researcher's name in WashU with 3,000 or whatever. What is it?
Catano?
Mm-hmm. Yeah, Catalano.
Catalano.
So in Catalano, the judge found that anything that had been done to the specimen was a work of medical art. And so if you transform it into cell lines, it's no longer the specimen, and the individual has no right to it. First of all, a donation of a specimen is a gift, and once they give it, they don't have a right to it. So and when you take data for whole genome sequencing as an example, it gets put on a computer, but that computer gets backed up every single day, and all those tapes, and then you share it with somebody else, you cannot put it back in the bag. Once it's out, it's out. All you can do is destroy the original specimen to the extent that there's any left and it hasn't been acted on already. So to me, it's again a meaningless gesture.
Well, for many for whole genome sequencing, I would expect that we will want to periodically go back and resequence those specimens. So there is that caveat that the old ways of doing things, are going to change, and it's changing at the speed of light. So what was a whole genome sequence a year ago, in 2 years is probably going to be redone because it's not, we've missed a lot. So I think that, that's a rapidly evolving area.
But if you've created a cell line so that you can do it next time, or you've extracted the DNA so you can do it again, then that's no longer the specimen. That's a product of the specimen, and it's not the same. People have the right to withdraw their specimen.
Mm-hmm.
So that's the original form. If it's not in that form anymore, it's been transformed. And that's a federal decision. So I think that would hold sway. I think people should be told if they have broad consent that they probably can't withdraw their consent. Why do we give them all the options that aren't really true?
And why do you protect my specimen if it's just a de-identified specimen? It could be, Hollywood blood. What makes it me is my data.
Right. There are a few more questions that came through. Let's see where I left off here. So, I'm going to start from the bottom and work my way up. So I'd love to hear Mr. Payne's response to the point just raised by the panel about genome research requiring consent if it's obtained via a biospecimen versus if it's obtained clinically. Is it accurate that a genome obtained clinically doesn't require consent for research in the way that genome from a biospecimen does in NPRM? And if so, why that distinction?
Yes, in the primary proposal in the NPRM, that is correct, that if you generated a whole genome sequence for clinical purposes from a specimen, that would not require consent for research because it would not constitute research. Now, if that whole genome sequencing, or that whole genome sequence was to be used in an identifiable form in research, that would require consent. If it was to be used in a de-identified form, that would not require consent. And when I say de-identified, I actually mean non-identified, because that's the term that's used in the Common Rule, which is a different standard than what is set by HIPAA, which refers to de-identified and has 18 specific pieces of information that would have to be removed from the whole genome sequence. Now, the NPRM does not propose a change in the sort of standard or definition of identifiability. So if you think that it should be different or that it doesn't adequately, expand and protect certain types of data that it should, then perhaps that's a comment you should consider submitting. I suppose the other aspect of it, though, is that there are, there is a division introduced in the NPRM between the Common Rule and HIPAA. And so information that is subject to HIPAA is no longer subject to the Common Rule. Now, the vast majority of whole genome sequence that is being generated today and recently has been for research purposes and not for clinical purposes. It's conceivable that in the future, whole genome sequencing might be generated much more commonly and become a part of clinical practice, but I think it's pretty safe to say that we're not quite there yet. If that did become a case and it did commonly become part of EMRs or medical records, then in that case it would be subject to HIPAA and would no longer be subject to the Common Rule. So there would be a sort of analogous protection in place. Now, granted, it might take some time for that to be considered to be part of HIPAA, and so there would be a gap that certainly would exist. But I guess there's a question about when whole genome sequencing would become a sort of standard part of clinical practice. And the other aspect to this is that there are two alternative proposals in the rule that we haven't discussed very much. One of them focuses on requiring consent for the generation and use of whole genome sequencing data, regardless of whether it's identifiable, which in a sense is, sort of stating that it could be identifiable. And the alternative proposal to that is to require consent for the generation and use of information that is unique to an individual and could be used to re-identify them in combination with other publicly available data.
I just want to mention that we have OHRP is also on the line. We have Julie Canachero, Ivor Pritchard, and Lauren Hartsmith on the line, so questions can also be directed towards them, correct? Great. Any other further comments on the last?
I just wanted to comment that with the whole genome sequencing or generating the genetic data, or any research data where there's the intent to return results, that it is subject to the common rule and does require consent, as I understand it.
That's right. Even if it's broad consent, which would normally be exempt, the NPRM proposes that there would be IRB review of any plan to return results.
So HIPAA does cover individually identifiable health information.
Mm-hmm.
And so research data, whether genetic or not, that is at a covered entity, it's part of research and not clinical care, is still covered by HIPAA. And so, I wasn't clear when I read the NPRN if the exception for HIPAA applied just to operations or to everything. Like what is the exception for HIPAA? To me, that needs a little clarity. Are we just excluding those things? Because otherwise everything's covered by HIPAA. The IRB will have nothing left to do. We might as well close down.
Well, specifically what it says in the rule is for activities that are regulated by HIPAA as research, healthcare operations, and public health surveillance, I think.
So that's almost everything.
So I have a long question here, if you're ready for it. So why is the public officials exemption being dropped? Have political scientists and others studying governments, i.e. the state, in the U.S. and abroad been consulted about this change? Dropping this exemption may make studying governments, both democratic and autocratic, more difficult. This change threatens the ability of researchers to study powerful actors. In contrast, the ability of social scientists to study governmental and other powerful actors is recognized in the Canadian Human Subjects Protection Policy.
Well, this is an interesting change that occurred. It's an exemption, I believe, and I think it's focused more on public benefit and service programs. But I wonder if OHRP is on the line and could maybe provide a little insight about this change.
This is OHRP. I'm afraid there was a side table talk. Could you repeat the question again?
I would love to. Are you ready? Why is the public officials exemption being dropped? Have political scientists and others studying governments, i.e. the state, in the U.S. and abroad been consulted about this change? Dropping this exemption may make studying governments, both democratic and autocratic, more difficult. This change threatens the ability of researchers to study powerful actors. In contrast, the ability of social scientists to study governmental and other powerful actors is recognized in the Canadian Human Subjects Protection Policy.
So, are you referring to the exemption in the existing common rule, or are you referring to the new proposed exclusion?
This was from one of our viewers that was tweeted in, texted in, or emailed in. So we might just have to make some assumptions. They're flipping a coin now of who has to answer.
Yeah.
And I think, this is Julie Canachero, I think the reasoning was that we were believing that the new exclusion that we created, that is modeled on the current exemption 2, which is very similar to the one I think that the questioner is asking about, would adequately address that sort of research, in that it would permit survey research, for example, to be carried out with anyone, not just necessarily government elected officials, provided that either non-sensitive information were not being collected, or identifiers were not being collected if sensitive information were being collected. And I guess the other exemption that we proposed, we thought might cover the sort of research that wouldn't qualify for that exclusion, recognizing that there could be research carried out with people, including elected officials, that could in fact be both sensitive and identifiable, in which case the privacy safeguards would need to be adhered to. So I guess it wasn't clear that it was necessary to retain the current exemption that's being referenced in the question. But if it's believed that we ought to, and there are some examples of research that's thought to be important and appropriately, exempted outside of the two, or excluded outside of the exclusion and exemption that I mentioned, we'd certainly be interested in knowing that.
And just to add on to that, I think that the new proposed exclusion, which has to do with activities that involve focusing on the specific individuals about whom one collects information, would enable one to carry out some kind of inquiry which is excluded from the common rule requirements entirely, which would focus specifically on evaluating whatever powerful figure one was interested in.
There is a follow-up question to that, which is, will there be an ongoing evaluation process for evaluating the effectiveness of the tool in making accurate determinations for exclusions?
I don't think there's anything in the NPRM that is specific to doing some kind of evaluation to assess the reliability of the exemption tool. I would imagine that if questions were to arise, that's something which could be done, but the NPRM doesn't make a commitment to that, to do that.
Very good. Another question. The NPRM...
I'm sorry, can I...
Sure, go ahead.
I'm sorry, can I just interrupt real quick?
Yes.
Sorry about this. Participating on the phone, this is one of the hazards of it. Just in response to the question that came earlier about HIPAA, I just wanted to clarify one thing about that in case there might be some misunderstanding about the exclusion that we were proposing related to the use of protected health information that's covered under the HIPAA rules as either healthcare operations, public health, or research activity. And I think there was a comment made that, for institutions who are in fact covered entities, that this exclusion would basically take off from the IRB's plate all research that would currently be covered by the common rule. And I guess I just wanted to point out that this exclusion is limited to only the secondary use of information. So, if an institution only carried out research involving the secondary use of protected health information, then I think it would be the case then that if if the researcher were in fact covered by the rules, the HIPAA rules, that the research would be excluded. But for most institutions, I think that's probably not the case because this exclusion is not intended to cover research that involves some kind of intervention, right? Plus data collection, where the data collection itself would be covered by, or the use of the data would itself be covered by HIPAA. So I hope that clarifies what we were intended, but if not, be happy to talk more about that.
Any other questions in regards to that statement? Okay, so I think this might be one of our final questions. The NPRM seems to focus significantly on limiting researcher access to biospecimens without consent, but doesn't provide much detail regarding protections for clinical data. Is there evidence to suggest that people are more concerned with the privacy of their biospecimen data than their clinical data to support these proposed changes? Does anybody else feel like they're playing Trivial Pursuit? Do you need me to repeat that, or Totten, you going to tackle that?
Well, I suppose I would say that if you read the preamble, there's a significant section in it that talks about the rationale for the changes that are being proposed. And one of the sort of bodies of literature that is cited as, I think, kind of the main reason for changing, for putting in place a requirement to obtain consent for the use of biospecimens is not about whether they are more concerned with the use of their biospecimens than their clinical data, but rather whether participants want to be asked for the use of their biospecimens. And the literature cited there, I think, generally supports the claim that most people, the vast majority of people, want to be asked for the use of their biospecimens.
My question is, I have no problem with asking people about the secondary use of their biospecimens when they're already participating in research. Is there a similar body of data, because I certainly am not familiar with it, that patients who have their blood drawn want to limit what's done with their extra specimens, and that surgical patients want to limit the use of those? Because our consent forms, as long as I've been around, have always said that whatever's left over is going to be used for research. I mean, that's one of the options. And our HIPAA form, when you sign into the hospital, says that your information will be used, may be used for research. So I'm not sure that the same body of evidence applies to the clinical situation, and that's going to be the biggest impact.
The only studies that I can think of, and I'm sure there are others, were around the Vanderbilt Biobank, BioView, in which they use leftover clinical samples for their biobank. And these were completely de-identified, or the samples were, I think you could consider them anonymized. And they actually conducted a number of focus groups and went to patients as well as people within the institution who worked there, and asked them about their opinions. And it, for the most part, people were very comfortable. And I think it was partially because these were anonymized or de-identified specimens, and wouldn't be linked to them in any way. And so that's the only real study that I know of. They did a series of them, and they also did this in a pediatric, their pediatric hospital as well, which found similar findings.
My impression is that much of the drive for this comes from the Havasupai case, where people looked at a use of the specimens which was to a purpose, which was not one with which the donors were comfortable, and they were not asked specifically about that use, the ancestry use. But it's bad policy to use cases of one to create generalizations, and this is an example, I think, where, at least to my mind, you've generalized something that was not really an issue for most people.
So there is another question. The NPRM seems to focus significantly on, did we do this one already? I might have read this one already. The NPRM seems to focus significantly on limiting researchers' access to biospecimens without consent.
I think we have this.
We do that
Did
one?
that one. Yep.
Sorry about that. All right. Wait, one more question from the live stream. Has there been research looking at how people feel or are being asked about use of their data versus tissues? This is a much newer question than the tissue question. I imagine it's the same.
I think most of the research has conflated the two. I'm not really, and I may be missing a body of literature, I apologize if I am, but I think that most questions of the public of this nature have focused on things that would come out of biobanks, where you're collecting a specimen and deriving data from that. And I think it's difficult to separate the two in that way.
Okay, so I have a final question for each of the panelists.
You also have a question from...
Oh, I'm sorry, go ahead, thank you. Nope, you go.
So my question is more about the change from some of the categories of exempt research to the exclusion research. And it seems like investigators can now do a self-exemption. Is there any preference on how people who will be making the determination for the exclusion research, if that'll be investigators deciding themselves, or if there's going to be a tool, or if they should still go through the IRB? Because I feel like one of the reasons why IRBs are hesitant on self-exemptions now is that they don't necessarily know that the person making the call has all the expertise. So it seems like we're just bumping everything down, but we're going to have the same problems.
Well, I think the tool generally requires that it be used by an expert with knowledge of the regulations. But yeah, in general, I think though it's possible that the investigators themselves, in some circumstances, can use it. Is OHRP on the line? Like, do they have some insight into how the tool will be used, like especially for exclusions, because the NPRM doesn't address how. Well, it doesn't require that the tool be used for the excluded categories of research.
That's correct. The exemption tool is proposed for determining whether an activity fits one of the exemption categories. The NPRM is silent with respect to decisions regarding exclusions and who or how those decisions would be made. It is similar to the current circumstance with respect to decisions about whether something's research or not, or whether something involves a human subject or not. It is up to institutions to decide how they want to exercise the procedure for deciding whether exclusions, whether an activity falls under an exclusion or not, just as with deciding whether something's research or not, or whether human subjects are involved.
And this is Julie, just with regard to the question about, or the issue about whether the use of the decision tool requires someone who's knowledgeable about the exemptions. It's proposed that there wouldn't have to be knowledge of the exemptions or be an expert in them in order to use the decision tool, because it's thought that the decision tool would be, I guess, specific enough and clear enough about the questions that it would ask, that provided accurate information were submitted to the tool, that it would generate a correct response of either yes or no, or if it was ambiguous, that it would direct the individual inputting the information to consult with someone who were knowledgeable to determine whether the activity was in fact exempt.
I'm not certain how this advances beyond where we are. It's just a different set of rules. There's an algorithm that currently exists. Is that just going to be electronified, if you will, into a decision tool? I think that I don't think it changes the landscape at all.
And one of my concerns is, my understanding is that institutions have to track this research. So the IRB is going to have the burden of tracking when the tool has been used and the research found to be exempt. And it also shifts the burden to the monitoring group for the institution to make sure that the research follows what was used in the tool. So we're just shifting the burden.
Actually, yeah, I mean, technically no, because if they're still accountable, it's going to go back to how it is.
I mean, there are many IRB officials here, but I only know from discussions with my IRB that they would much rather investigators ask them whether something is exempt or not. And so I find this really interesting that this effort to exclude them, people who are knowledgeable about it and going through the algorithm, because it is, I've worked with a number of investigators regarding that issue, and it's very confusing for some types of research, and I really do think that it will likely need to be someone knowledgeable in order to answer the questions. So I don't really see it changing much either.
So we have an electronic application, and it provides guidance about the categories, and even so, 50% of the things that come in for determination of exemption turn out not to be exempt. So relying on the least knowledgeable group of people does not seem to me pragmatic, and at least if you want to limit things, to have the appropriate justifications made. And personally, I'm opposed to including things in a regulation about human subjects research that aren't human subjects research. I mean, put it in the preamble, put it in guidance, but I don't think you exclude activities from human subjects research that aren't human subjects research. You exclude activities that are human subjects research from human subjects oversight. So I'm all right with, the CDC and federal agencies, that's fine, but I think the only thing that should be excluded is human subjects research. But I don't, the first half a dozen or so are not research or not human subjects research. Like, what are they doing there? It would be like having rules for football that aren't going to be applied to baseball.
Any other comments before we move on to the final question for each of our panelists? Great. So, posed to each of you up here, if you could choose to comment on one section of the NPRM, what section would it be and what would you say? Should I start down here?
I'll start. I'll go a little light, I guess, with the consent posting. The 60-day requirement post completion of enrollment is, to me, absurd. It loses its function. That if indeed they need to be posted, which I think clinicaltrials.gov is a reasonable platform, and then provides that strata of consent documents that would undergo scrutiny as well as have some utility for patient populations to be aware of what those studies are about, as that information is conveyed in that document to those candidate subjects, that it would be posted in the active phase of recruitment.
Great, thank you. Maureen?
For me, it would be this is no surprise, the consideration of de-identified biospecimens being considered human subjects research, or coming under the purview of human subjects research.
Great, thank you. Amy?
I would say the mandate for single IRB review for multi-site research, there should be an opt-out option. There's so much variability in expertise, and the way responsibilities are dictated under so many different agreements that I think institutions need to be able to say, not for this one.
Thank you. Dr. Schreiner?
I'm concerned about the definition of human subjects research as it applies to biospecimens. So I would revise that.
And probably to nobody's surprise, I would focus on the informed consent process and the need to actually have language around the process and de-documentize the focus of this NPRM, because I think it was so document-focused that it is solving the wrong problem in the wrong way by making a situation worse.
Hear, hear.
And I would just like to say that I think the e-consent is the way to go, and to keep patients involved from every point along the way.
Any final comments from OHRP on the phone, or no final comments? Anyone from the phone?
Nope, just submit your public comments, please.
I'm feeling confident that everyone in this room is going to submit an official comment. They've seen it on the screen long enough. I think they have enough information here today that everybody will submit something, which is actually a good question. What does that comment have to be? A 6-page dissertation? Is it short and sweet?
No, it can be anything you want. I think any length is allowable. You can answer the questions. You don't have to answer the questions. You can comment on any part of it. You can comment in general or on specific aspects. So.
That's great. Well, thank you. And I'd like to just say thank you to everyone who made this event possible. I'd like to thank National Center for Advancing Translational Sciences, the Office for Human Research Protections, Genetics Alliance, the CTSA Consortium Coordinating Center, all of our wonderful speakers here today, and everybody in the back of the room who made today possible. So thank you, everybody, and thank you for submitting comments. Excellent. Thank you so much. Great.